Welcome to meeting number 26 of the Special Committee on Canada-China Relations. Pursuant to order of reference of Wednesday, September 23, 2020, the committee is meeting on its study of Canada-China relations. This
is a hybrid meeting pursuant to the motion adopted by the House on the 25th of January 2021.
The motion adopted by this committee on Monday, April 26, 2021. The purpose of today's meeting is for the Public Health Agency of Canada to explain why the requested documents were not provided in accordance with the committee's motion for the production of documents adopted on Wednesday, March 31, 2021. As a reminder, this motion called for unredacted documents related to the transfer of viruses that occurred in March 2019, the revocation of security clearances and the termination of employment of 2 employees from the National Microbiology Laboratory.
These documents were to be handed over to the Law Clerk and Parliamentary Council before the 20th of April 2021. First of all, I would like to thank the Public Health Agency of Canada for having accelerated the translation of the missing documents. All of the documents in the 2 official languages have now been made available around midday today for the members of the committee in the digital binders. Before we go on to the witnesses, I would like to clarify with members the way in which we will proceed this evening for the rounds of questions. The clerk has received divergent opinions from the vice chairs. So I would like to suggest a compromise, namely,
witnesses be given up to 10 minutes for their opening remarks, that we do a first round of questions followed by a second round and a subsequent round. We'll then take a health break. This should be around 8 p.m. and then repeat for another first round followed by a second round and a subsequent round. Are there any objections to this? Not seeing any. I'd also like to remind everyone that while witnesses must answer all questions which the committee puts to them, members have been urged to display appropriate courtesy and fairness when questioning witnesses, as of course the House of Commons Procedure and Practice provides at page 1079. I would now like to welcome our witnesses.
From the House of Commons, we have Philippe Dufresne, Law Clerk and Parliamentary Counsel, as well as Michel Bédard, who is the Deputy Law Clerk and Parliamentary Counsel.
Health Agency of Canada, we have Ian Stewart, President, as well as Dr. Guillaume Poliquin, Acting Vice President, National Microbiology Laboratory. Finally, from the Department of Justice Canada, we have Christian Roy, Executive Director and General Counsel, Health Legal Services. Welcome, everyone, and thank you for being here. I will now turn to Mr. Stewart for the opening remarks. Please proceed.
Thank you, Mr. Chair. As mentioned, I'm here with my colleagues, Dr. Guillaume Poliquin and also Christian Roy from the Department of Justice. Members, I want to begin with the steps we've taken to respond to your motion of March 31st. We've reviewed the relevant documents and worked very hard in a short period of time to prepare the package of documents that will assist you in your study. As I indicated in my letter to your law clerk, Monsieur Dufresne, we've redacted documents where the information pertains to personal information, investigations, or security matters. The reason we've done so is that as public servants, we're bound by law to keep confidential information confidential. It's not that we're wishing to be uncooperative or unresponsive. We are disclosing as much as we can within the limits of the law. The Government of Canada guiding document entitled Open and Accountable Government has been used for many years to explain the obligations of witnesses before parliamentary committee. I note in particular the passage in Annex E. Public servants also have a duty to hold in confidence some of the information that comes into their possession in the course of their duties. There's a tension between that obligation and the request of parliamentarians for disclosure of that same information. When appearing before parliamentary committees, public servants should refrain from disclosing the kind of information, confidential information, for instance, because the information is confidential for reasons of national security or privacy. That's Annex E of Open and Accountable Government. Consistent with this guidance, in good faith, we've considered how to find ways to respond to the requests for information from the members of the committee within the limitations that we're bound to uphold. This includes my obligation under the Privacy Act, which is legislation enacted by Parliament and the House of Commons to protect from the disclosure of personal information and the infringement of the privacy and rights of individuals. In compliance with that advice, we have applied redactions to protect certain sensitive information. Accordingly, I'll do my best to assist the committee in this study while refraining from divulging information that ought to remain confidential on various grounds. I have no authority to disclose any additional information to you. As you'll see, the limitations on what we can disclose is consistently well documented throughout the package materials that we've provided to you, which include public communications and previously disclosed access to information documents. The limitations that guided those documents remain in place. Here's what we can say about the two matters we discussed last time. You've received many records from the Public Health Agency related to the transfer of Ebola and Henipah viruses from the National Microbiology Laboratory to the Wuhan Institute of Virology in March 2019. The basic chronology of the transfer can be found at page 111 of the package provided to your law clerk. These records demonstrate that when sharing these samples, the NML followed normal internal guidelines and all applicable requirements under the Human Pathogens and Toxins Act, the HPTA, and regulations, as well as the Transportation of Dangerous Goods Act, TDGA, and regulations related to it, and the Canadian Biosafety Standard. Here's how a transfer normally works. The NML routinely receives and shares samples with other public health laboratories. To contribute to the advancement of science, transfers follow strict protocols, including the requirements I just mentioned, as well as NML standard operating procedures. The NML has detailed procedures outlining the steps required for transferring risk group 4 pathogens in accordance with the Transportation of Dangerous Goods regulations. These include detailed procedures outlining step-by-step roles and responsibilities for all involved in the shipment, what documentation is required by the NML and from the receiving laboratory, when to initiate an emergency response assistance plan, an ERAP notification, as well as how to package the samples. Approvals are required at various steps throughout the process, from the initial transfer authorization to the specific shipping details. The shipping process for risk group 4 pathogens is outlined under the mandatory ERAP. The plan assists local emergency responders and describes what to do in the unlikely event of a release of materials while they're in transit. Regarding the March 2019 transfer, documentation of the necessary approvals is evidenced in pages 265 to 271 of the English package, including the NML transfer authorization. A number of the emails relate to that was put in place for the shipment, such as page 132. However, full redactions were done to the laboratory certification and the letter from the director of the laboratory, as this was third-party information. You will note reference to material transfer agreements, MTAs. It's important to understand that an MTA was not in fact required at the time for virus transfers. An MTA is not a safety requirement, but a document that provides a mechanism for transferring controlled materials from one party to another, primarily to safeguard intellectual property rights. As such, IP experts are consulted to determine whether an MTA is required. While this is the only time that we have shared virus samples with this particular lab, collaborations with labs outside of Canada are critical to advance public health research into infectious diseases. PHAC's National Microbiology Laboratory is internationally renowned for its scientific excellence and its contributions to global health. This maximum containment laboratory has a long-standing international reputation for sharing materials for the purpose of advancing scientific knowledge. Given our standing as a WHO collaborating partner for viral fever viruses, as well as our knowledge on regulations and standards for these types of transfers, the laboratory in Winnipeg is often asked to provide materials to new or existing programs, including laboratories in the United States. The NML is open to providing materials in a safe, responsible, and transparent fashion with other labs. In order to foster global collaboration, rather than enable research on any given disease to be monopolized by specific teams. This is a component of advancing public health research and science aimed at improving public health on a global scale. You will notice that one of the individuals named in the motion was involved in this transfer. Regarding the situation of the two individuals named in the motion, we've already confirmed that they no longer work for the NML. We've also mentioned that there had been an administrative investigation. We cannot discuss the nature of the administrative investigation, its scope, nor its findings. That said, to avoid undue inferences, I want to state again, as is evidenced throughout the documentation that you've received, the fact that the transfer of the viruses took place, which again was done in compliance with internal policies and proper approvals, is not connected to the departure of the two employees. As you know, there's also an RCMP investigation. On that matter, I cannot comment, and questions should be directed to the RCMP. I'm happy to take your questions about these documents and answer them as best I can. Thank you very much.
Thank you very much, Mr. Stewart. I think I'm correct. Je pense que j'ai raison que Monsieur Roy, vous n'avez.
I think, Mr. Roy, you don't have a statement. Good evening, Chair and members of the committee. No, I don't have an opening speech, but I'll be happy to respond to any questions that you have. And now, Mr. Dufresne, do you have a statement to make? No, Chair, but I'm in the hands of the committee to answer your questions when needed. Thank you very much.
To our first round of questions, and I believe it's Mr. Chong for 6 minutes.
Thank you, Mr. Chair. We still don't know the origin of the coronavirus. That's because the government of China has blocked the investigation into the origins of the COVID-19 pandemic. Not only did the government of China delay the start of this investigation, they did not allow WHO investigators unfettered access to pursue the scientific evidence. As a result, the world still does not know where the virus came from. Determining the exact origin of the virus is essential if the world community is to prevent the next pandemic. The government of China has been opaque and anything but transparent when it comes to investigating the origin of the coronavirus. Here in Canada, we have another investigation going on that concerns viruses. An investigation that concerns the shipment of Ebola and Henipa viruses from the National Microbiology Lab in Winnipeg to the Wuhan Institute of Virology on March 31st, 2019, just 8 months before a global pandemic ostensibly began in the same city. An investigation that concerns 2 Chinese scientists employed by this lab in Winnipeg who were terminated, Dr. Chu and Dr. Cheng, who were terminated on January 20th of this year for quote-unquote policy breaches. And here, like in China, the government of Canada is blocking our investigation into the transfers of these viruses to the Wuhan Institute of Virology and blocking our investigation into why Dr. Chu and Dr. Cheng were terminated. The parallel between these two situations is appalling. We live in a parliamentary democracy, and we are facing the same impediments to our investigation as investigators are facing as they attempt to discover the origins of the COVID-19 pandemic in China. Dr. Chu and Dr. Cheng were escorted out of the lab by the RCMP, along with Chinese students on July 5th of 2 years ago. In the months before they were escorted out, the government of Canada replaced Dr. Chu's computer at the lab and denied her permission for trips she applied to China. But we still don't know why she was terminated. Dr. Chu had made 5 trips to China in 2017 and 2018. She was invited to the Wuhan National Biosafety Laboratory of the Chinese Academy of Sciences twice a year for 2 years for 2 weeks at a time. One of those trips was to train scientists and technicians at China's new Level 4 virology lab in Wuhan. But we still don't know why these two scientists were terminated from the Government of Canada's lab in Winnipeg because the Government of Canada is blocking us from getting this information that we ordered through a motion that we adopted on March 31st of this year. Mr. Stewart, you say that you are bound by law. Open and accountable government is not the law. It is a document produced by the PMO and PCO at the start of this government. It is not the law. Section 8.2c of the Privacy Act is the law. And Section 8.2c says, for the purpose of complying with a subpoena or warrant issued or order made by a court, person, or body with jurisdiction to compel the production of information or for the purpose of complying with rules of court relating to the production of information. That's the section of the Act that says where personal information may be disclosed. We, as this committee, are a body with jurisdiction to compel the production of information of Ebola and Henipah viruses to the Wuhan Institute of Virology in China, and to produce documents with respect to the termination of Dr. Chu and Dr. Chang. You are not in compliance with the law as adopted by the Parliament of Canada, titled the Privacy Act, under Section 8.2c, which expressly gives us the authority to compel the production of this personal information. So, Mr. Stewart, what do you say to the fact that you're not complying with that section of the Act?
Mr. Chair, thank you for the question. My understanding is that I am complying with the Privacy Act and its requirements. I am not an expert in this area, and I've taken expert advice in that regard. And for this reason, we have legal counsel with us here today. So what I would say is I believe that I am upholding my obligations under this Act of Parliament. And in that spirit, I'm trying to provide as much information as I'm able to do while protecting the privacy of the individuals involved in the matter at hand. Thank you for the question, sir.
Mr. Chong, that concludes your time, and now we'll go on to Mr. Oliphant for 6 minutes.
Thank you very much, Mr. Stewart. Thank you also for raising the issue of Appendix E of the Open and Accountable Government document, which I understand and I would agree.
Order, Madam Bruson.
Sorry.
Your microphone's not down. That's it. Thank you.
Sorry. Yes.
Sorry, I was eating my dinner. So thank you. And thank you for your public service, and thank you for working with this committee to find a solution to protect the privacy of individuals, which we would as parliamentarians, because that is an act that we passed, want to do, but also to provide us with information so we can better understand the situation at hand and do that. We recognize that that is a balancing act. And thank you for raising the operating document on open and accountable government, which is something that, yes, as Mr. Chong said, may not have the force of law. However, it is an operating document that has been quite a rerouting from the previous Harper government, which actually did not want to do open and accountable government and sought various ways to thwart that. And I speak of that very knowledgeably as someone who was an opposition MP during those times. So I understand that moment in history as well. And so we are attempting to have an open and accountable government. At the same time, we have questions that we want answered. You have raised the issue of being in compliance with the Privacy Act as public servants, which we're compelled to do. As you know, this committee is a committee of Parliament, and parliamentarians have certain rights and responsibilities as well. And so we're trying to square that off. And I would like to know a little bit about the legal advice that you got with respect to the redactions that you put into the documents, which were are quite real. We recognize that, and I find them frustrating myself, even as a member of Parliament from the government benches. And could you explain? And you're very welcome to turn to legal counsel from Justice as well. If you're not feeling comfortable with that, I'm very happy to have from either of you that outline of what criteria you would have used as public servants who are obligated to follow that law as well.
Well, thank you very much, Mr. Chair, for the question. I think, as I've mentioned, the Privacy Act, but also other considerations such as national security considerations pertain. One of the interesting things about going through the materials that's been provided to the committee is the consistency. I don't think any of the redactions occurring in these materials provided to you vary from the history of the documents provided. In fact, there's a consistency in what's been able to be provided and not provided. In fact, some of the materials speak to that. I think you'll have seen from reviewing the documents. So I would say that we're following the normal limits that pertain in this area. And so it's protecting third-party individuals' privacy. It's protecting national security considerations, and as much discussed in our deliberations with my time before this committee, of course, the Privacy Act and the privacy of the two individuals. And I think you see that reflected through all the materials that were provided, sir. So thank you for the question.
You mentioned in your remarks that there's also an ongoing police investigation by the RCMP doing this. Did that enter into your decisions with respect to redactions? I know you mentioned we should ask some of those questions to the RCMP, but these documents came from the Public Health Agency of Canada and are wondering about that role of a police investigation, and did it play a part?
Mr. Chair, thank you for the question. We endeavored to make sure that nothing that we were relating was connected to the RCMP investigation. We're not part of that process, and we don't really have line of sight into it. So that's why last time I appeared, sir, I suggested it might be appropriate to raise that particular matter with the RCMP as opposed to us at the Public Health Agency, given our non-involvement in that activity.
By aspersion, Mr. Chong raised issues with respect to COVID-19 and the pandemic that we are undergoing right now, and this set of incidences. And my great concern is obviously misinformation. People and the public are prey often to political motives and misinformation. And I just want to know whether there is any sense of concern that you have with respect to that drawing of possibly totally unrelated activities into something as though there was a conspiracy at hand. And I did note that Mr. Chong mentioned Chinese a number of times when he was referring to the two individuals at hand. And just wondering if that conspiracy set of circumstances was of a concern to you.
Thank you for the question. You will have noted, I think, in the review of the materials that none of them pertain to coronavirus or research related to coronavirus. It's two other viruses, HEPA and, my time's over.
Very good. But thank you very much for that. I want to be very clear that this has nothing to do with coronavirus.
It's Mr. Oliphant's time. It's over, actually. Maintenant, on continuera avec Monsieur Bergeron.
So now we'll continue with Mr. Bergeron for 6 minutes. Thank you, Chair, and I'd like to thank our witnesses for being with us this evening. Mr. Stewart, I'd like to thank you for the documents that you've transferred to us. Perhaps they're not as complete as we would have liked, and we'll be able to discuss that together this evening. We'd also like to thank you for the explanations that you've given this evening up until now, even if perhaps it may seem rather unsatisfactory. But one of my main personal concerns was to see how the transfer of these viruses to Wuhan took place following all of the rules. But nevertheless, these two scientists were terminated. You've clearly established, and I think that resolves part of the problem, you've clearly established that there is no link between these viral transfers to Wuhan and their dismissal. Having said that, we're still trying to understand the reasons for their termination. You think that the rules of the Parliament refer to these people as if they fall under the Privacy Act, and they're saying that we cannot transfer information about citizens to the Parliament. But as Mr. Chong has already pointed out to you, the Privacy Act allows certain fora to ask for documents and information and obtain them forthwith. Now, I imagine that you would have never dared to transmit redacted documents or refuse to answer before the court. And here, the Parliament is acting like a court, and the Privacy Act itself, as is the case with all Canadian legislation, has to be constitutional. It has to meet what we have in the Canadian Constitution, namely the fact that it confers a parliamentary privilege, which often takes precedence over certain legal provisions. And it's under this parliamentary privilege and also the provisions of the Privacy Act that we believe that we're vested with the power to ask you to give us these documents in an unredacted form and answer our questions. Of course, parliamentarians are not irresponsible. Parliamentarians understand that there is personal information that should not be publicly disclosed, and there's information that should not be publicly disclosed if they're related to national security questions or questions related to a criminal investigation underway. That is why we'd offered you the option of communicating this information to us under the protection of an in-camera session so that we would not share this information with the public. But in spite of having made that offer as parliamentarians towards you, you have chosen to not respond to any of the requests from the parliamentarians. Of course, you have given a few more specific comments, but you have not given us unredacted documents, nor have you answered the fundamental questions we've been putting forward as MPs from the very outset. So I'd like to put a question to Mr. Christian Roy. Legally speaking, what leads you to think that the Public Health Agency of Canada, PHAC, is authorized to not respond to requests from parliamentarians? And this is in contravention with the sections that have been cited by Mr. Chong in the provisions in the Privacy Act and also under our parliamentary privilege.
Merci pour la question, Monsieur.
Thank you very much for that question. May I answer, Chair? Yes, thank you. We, of course, recognize the power of committees to ask for documents and call witnesses. Having said that, when we talk to Section 8.2, we talk about being compelled, and that's where there's a difference of opinion, I believe, with the committee's opinion. We do not recognize the power for the Parliament to compel this. Nevertheless, the senior officials of the government continue to have obligations vis-à-vis the Crown and the primacy of law. Namely, they have to respect the laws that have been enacted by the Parliament, and where the Parliament has conferred right to have protection of the privacy. Now, President Mr. Stewart, in his correspondence and in his opening speech, is in conformity with the position that's been put forward by the senior officials and ministers for at least a decade now. So it's not necessarily a new position that's being expressed. Basically, it's whether the question is whether the committee can compel production or not of these documents, as we see under Section 8.2c. Thank you.
Vous êtes en sourdine, Monsieur le Président.
You're on mute, Mr. Chair. Thank you. Mr. Bergeron, your time has run out for the moment.
Press, please, for 6 minutes.
Thank you, Chair. And Mr. Waugh, you just explained the obligations by the statute, for example, the Privacy Act that senior public officials may have with respect to making documents public. The advice that we have been given and the rulings of the previous speakers of the House, and which are constitutional in nature, provide that committees do have the right to obtain documents, whether or not the Privacy Act speaks the way it does, and that anything within the control and knowledge of the executive is available to the Parliament with certain concomitant conventions or obligations on the other part. So you're speaking, I take it, in connection with the obligation of officials with respect to ATIP requests, with respect to privacy legislation and other legislation that might apply when making information available to the public. Am I right?
I'm speaking in, thank you, Mr. Chair. I'm speaking in relation to the powers of committees as well.
Well, I perhaps, and I can ask Mr. Dufresne to repeat, I guess, what he told the committee with respect to the powers and interpretation of the ability of our committee and the Parliament itself to call for papers and documents in regard to the redactions that we're seeing here.
Certainly, thank you, Mr. Harris. And as indicated in previous appearance that I've given, the committee's powers to send for papers and records comes from the Constitution, comes from Section 18 of the Constitution, comes from parliamentary privilege, and gives the power to send for persons and papers. It's constitutional. It is at a higher level than ordinary statutes. And Speaker Milliken in his ruling and the Supreme Court of Canada have recognized the primacy of constitutional provisions, in particular parliamentary privilege. And indeed, the document cited in terms of the government's policy on the 2015 document cited today refers to Speaker Milliken's decision in 2010. And so it's the same authority that is pointed to. And that authority from Speaker Milliken makes very clear, as do the authority in other parliaments, that the constitutional authority of committees and of the House supersedes and is not limited by ordinary statutes like the Privacy Act or the Access to Information Act. And so these are important public policy considerations, but they do not limit. And Speaker Milliken was explicit on this point. It was explicit that the statutes did not allow the government to unilaterally determine that something would be confidential. It may well be that the House and committees will agree with the submissions, but at the end of the day, it is to the committees and ultimately to the House to decide.
And would you explain what precautions that this committee has made within its motion calling for these papers to respect the kinds of convention that might provide protection to ensure that information that may perhaps ought not to be made public would not be made public, and that the committee members would have an opportunity at the same time to independently assess the validity of what we're being told, or the nature of it, or the consequences of what we are being told by the government.
Well, certainly. And this, indeed, just going back to the government document that was cited today, quoting from Speaker Milliken's ruling, the mention was that the committees or the House will often agree with the positions put forward by the government as to a basis for confidentiality. And indeed, the fact that committees have the power doesn't mean they have to exercise it in all cases, and they're valid, important public policy considerations. So there are many tools that committees can take, looking at documents in camera, having only committee members have access to the information, having briefings done in a confidential manner, having the documents, the proposed redactions reviewed by a third party, which could be my office, or in the case of the Afghan detainee case and the Speaker Milliken's ruling in 2010, there was a creation of a committee with parliamentarians and arbiters and judges. So there was a process, but at the end of the day, the last word was for committees and the House. And so the process here that was put forward was that my office would review the documents with the possibility of proposed redactions by the government, and that an opinion can be given to the committee.
And in connection with that, sir, we have, for example, on the 271 pages we've been given, I don't know how many of these pages have been given to somebody else. I guess I will ask that the next round to Mr. Stewart. But, you know, we have things like 12 pages not relevant, 8 pages not relevant, 3 pages, Privacy Act, 11 pages. You know, in terms of relevance, for example, if there were matters that were irrelevant, I'm assuming we could rely on you if you knew what we were looking for, and there were 12 pages of stuff there that had nothing to do with our inquiries. You could say, look, these pages are not relevant, and they've said they're not relevant, and they're correct, and we would presumably take your word for that as counsel to the problem. So that's a possibility as well. Is that correct?
Thank you, Mr. Harris. Thank you. Thank you very much, Mr. Harris. We'll now go on to the second round, and we have Mr. Jennis for 5 minutes, please.
Monsieur le Président.
Chair, Mr. Bergeron. I didn't hear the answer from Mr. Dufresne. He said yes. Thank you very much, Chair. Thank you.
5 minutes.
Well, thank you, Mr. Chair. And I do want to maybe just note at the outset that I think Mr. Chong's questions were manipulated by Mr. Oliphant to imply he had said something that he had not said. I think Mr. Chong's points were quite clear about making an argument about how in our system we have the supremacy of Parliament, which means that we would expect that when there are investigations into important matters, there would be a greater level of transparency here. You know, Mr. Dufresne, thank you for your very clear comments about the fact that there is constitutional authority that committees have to send for documents. This has been upheld by the Supreme Court and by Speaker Milliken's rulings, that there are important public policy considerations at play that committee members will take into consideration, and it's ultimately up to them to take those matters into consideration. Mr. Roy, if you can just respond to this. I mean, if we're to believe your version of reality, that there's no ability of committees to compel documents, then like what the hell happened with the Afghan detainee case? Like what's your interpretation of the events that took place in the Afghan detainee situation if you don't believe there's a right to compel the production of documents?
Thank you for the question, Mr. Chair. I mean, respectfully, the power to send for records is not absolute. That is the position we're taking, and it must be balanced and circumscribed by principles.
Mr. Roy, I asked you specifically about the Milliken ruling. Yes. Is your position consistent with Speaker Milliken's ruling, in your view?
The ruling ultimately, if I recall correctly, was amounted to an order from the House.
Is your position about the rights of committees consistent with Speaker Milliken's position on the same question?
Our position is essentially that ultimately there are limits on the ability to produce documents as called for.
Is that the same as Speaker Milliken's position?
Mr. Jennis, well, Mr. Oliphant, do you have a point of order? I see your hand.
Yes, I was just trying to be a respectful point of order, Mr. Chair. Before it gets too far into the conversation, I would like Mr. Jennis to apologize for using inflammatory language, the word hell. I don't think that is parliamentary language, and the same rules of Parliament would also be the same rules. The rules of the committee would be the same as Parliament, and I think it is inappropriate, especially to a public servant who has come here as a witness to this committee.
Thank you, Mr. Oliphant. I think Mr. Jenness, I'm afraid Mr. Oliphant is correct. I would ask you
I'll
to
happily
retract
withdraw
that
the
word.
remark.
Thank you very much.
Mr. Roy, is your position consistent with Speaker Milliken's ruling?
With respect, Mr. Speaker, I don't think we can square the two, in the sense that my recollection of the Milliken ruling is that ultimately he asked that the parties discuss the matter and that they come up with a solution.
Okay, that's very honest of you. You're telling this committee that your position is different from Speaker Milliken's position. Do you believe that Speaker Milliken had the authority to make that ruling? And do you believe that his ruling has force of law?
Thank you for the question, Mr. Chair. I do believe Speaker Milliken had the authority to make the ruling and that it applied to the legislature in essence. There is a separation between the executive and the legislature, and rulings, as it's the same with decisions made by committee, have an impact within the bounds and within the separation of powers. Thank you.
Okay, so the speaker ruled, though, that parliamentary committees have a right to send for documents. Now, you said that that's not your position. You don't believe they have that right.
Right.
But you've also you've agreed that your position is different from the speaker's ruling. But you've also said that the speaker had the lawful authority to make that ruling in terms of the rights of committees. So I guess what I don't understand is how you are taking a position that is different from the position that the lawful authority has made in this case, and yet you presume to say that your position is still the legally correct position.
Well, as I said, it's hard to reconcile the two. My recollection is that the facts were different and that the order that was issued was different. The ruling was different in that ultimately he expected that the parties would agree, and ultimately they did come up with a mechanism.
That's what happened ultimately. But Mr. Roy, I think you've just defeated your own argument. Like, you've acknowledged that your position is inconsistent with the speaker's ruling, that the speaker had the right to make the ruling, but you still wish to persist in disagreeing with it. Mr. Stewart, are you at all embarrassed to be taking this advice over Mr. Dufresne's advice in your decision not to provide these documents to the committee?
Mr. Speaker, just to clarify, the question is, am I embarrassed?
Yes.
Mr. Speaker, with all respect, no, I am not embarrassed. I think what the legal counsel was saying was that, in fact, the cases are different and the equation that you're making doesn't add up.
I look forward to following up. Thank you, Mr.
Thank you.
Chair.
And I'll remind witnesses that I'm the chair, not the speaker. Now we'll go on to Ms. Zan for 5 minutes.
Thank you very much, Chair. I appreciate that. And listen, I've had to come across a number of times where my former MP, Bill Casey, had asked for documents and they came redacted, which he took great offense to as a parliamentarian, and has brought it up several times in the public eye, in the media, why a member of parliament can't receive documents that are unredacted. So I would like to ask the Public Health Agency, could they please forward unredacted documents to our parliamentary law clerk and request that he review them and ascertain the fairness? I think that would be a very good step forward. What would you say to that?
Mr. Chair, thank you for the question, member. My understanding is me providing materials to you is a disclosure. And so whether I provide them to the law clerk or to you, I'm making a disclosure. And that's where I run afoul of the Privacy Act. So we have done, member, all that we could to provide the materials that were consistent with what we understood to be our legal obligations. And I think if you review the package, you'll find that, in fact, much content is there. And in fact, it's quite repetitive and consistent content over time. Thank you for the question, member.
No problem. Thank you very much. And Chair, I wonder, might I make a motion that PHAC forwards unredacted docs to the parliamentary law clerk and requests him to review them to ascertain the fairness in them?
Mr. Chair, you're on mute.
Yes, you can make that motion.
I would like to make that motion, please, Chair.
And a point of order,
Mr. Williamson.
just a clarification from the chair. Is this motion, or perhaps even from MP Zan, is this motion substantially different from the motion that this committee had previously passed, asking the health agency to do just that?
Since we have not received the documents unredacted, I am asking that the PHAC send them to the clerk for him to review.
Madam Clerk, do you have the original motion? Could you read it to us, please? I've stopped the time, by the way.
Yes, thank you, Mr. Chair. So what I have here is essentially Ms. Zan asking the committee to reject the reasons that were provided from PHAC and to uphold the order for the production of documents. So essentially meaning that a new motion that the unredacted documents be provided to the law clerk.
Sorry, what I meant was the original motion, previous motion that we passed that led to the order.
Yes, give me just one moment here. So it would be the motion that was adopted by this committee on March 31st, 2021. Do you want me to read the whole thing?
Yes, please.
Okay. So I have that the committee send for all information and documents in the possession of the Public Health Agency of Canada or any subsidiary organizations related to the transfer of Ebola and Henipa viruses to the Wuhan Institute of Virology in March of 2019, and the subsequent revocation of security clearances for and termination of the employment of Dr. Chiu and Kidding Chang, provided that A, these documents shall be deposited with the law clerk and parliamentary council in an unredacted form within 20 days of the adoption of this order. B, that the law clerk and parliamentary council discuss with the committee in an in-camera meeting information contained therein, which, in his opinion, might reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation, so that the committee may determine which information is placed before a committee in public. And C, should the Public Health Agency of Canada not provide the documents in their unredacted form within 20 days, the President of the Public Health Agency of Canada and the Acting Scientific Director General of the National Microbiology Laboratory be scheduled to appear for 3 hours before the committee within 27 days of this motion passing to explain why the documents were not provided.
Thank you, Mr. Oliphant. You have your hand raised on a point of order related to this argument.
Yes, Mr. Chair. I'm not sure it's a point of order or whether you have ruled that the motion is acceptable, which I understand because the member had the floor and is able to make a motion. I understand that the motion is relevant to the discussion, so I understand that you would rule it in favor. I just now would think perhaps you might want to canvass the other members of the committee, because we could move right into that motion, but there may be some really important questions that the other members who've only had one round so far want to raise before we get into that motion. I think the motion is predicated on the disappointment that Ms. Zan has that we have not had the unredacted documents and is offering a solution, which I think Mr. Harris did sort of hint at towards the end of his questioning when he asked the law clerk, parliamentary law clerk, if he would avail himself to do that kind of work. And he said, yes. I just want your thought about whether or not we're now into this debate on the motion, which I think is a good motion. I'll be happy to support it, but I also don't want it to cut off Mr. Bergeron or Mr. Harris or the other members of the committee who may want to ask some questions before we get into it. So I just wanted to figure out, you're the chair and how you want to handle that.
Thank you, Mr. Oliphant. Well, the reason I asked, I'll get you in a moment if you don't mind, Mr. Jennis. The reason that I asked the clerk to read the motion in view of Mr. Williamson's point of order and objection that this was substantially the same as the motion, or at least in part as a motion already passed, was to assess that. Madam Clerk, what can you tell me about that? If you don't mind, Mr. Jennis, I'd like to ask the clerk about the provision regarding a motion that is substantially or partially substantially the same as a previous motion.
Thank you, Mr. Chair. In these circumstances, I would say that moving a motion to ask for the same documents again would be essentially the same as rejecting the reasons that the Public Health Agency provided to not provide the documents. So essentially upholding the committee's decision from March 31st.
Thank you. Mr. Jennis.
Well, thank you, Mr. Chair. I would just like to know what the text of Ms. Zahn's motion is, the specific text of it. We need that information in terms of how we vote on it, and we may wish to propose amendments to it as well. So I think she's moved the motion. We're debating the motion unless Mr. Oliphant proposes to do something else with it, but that would have to be considered. So I just like to know what the motion is, and then I would be probably interested in coming in on it on debate.
Thank you. Ms. Zahn, or Madam Clerk, do you have the motion? Would you like to read it? Is that why you're raising your hand?
I just wanted to let you know that Mr. Chong raised his hand as well in the room.
Yes.
The motion I have from Ms. Zahn is simply that the unredacted documents from the Public Health Agency of Canada be provided to the Law Clerk and Parliamentary Council.
Okay, thank you. Now, Mr. Jennis, your hand is still up. Is that on a point of order, or is it?
That would be on debate.
I have Mr. Chong on debate,
great.
And then I have Mr. Jennis, and then Mr. Oliphant. Mr. Chong.
Thank you, Mr. Chair. I support the motion, and I will be voting for it. Thank you.
Thank you very much, Mr. Jennis.
Thank you, Mr. I'd like to propose an amendment to the motion. It would read as follows: that the unredacted documents from the Public Health Agency provided to the Law Clerk and Parliamentary Council is the current motion. And then I would add the following: within 7 days. And should the committee, and should the documents not be provided, that the committee report the following to the House. Your committee recommends that an order of the House do issue for all information and documents in the care, custody, or control of the Public Health Agency of Canada and subsidiary organizations respecting the transfer of Ebola and Henipa viruses to the Wuhan Institute of Virology in March 2019, and the subsequent revocation of security clearances for and termination of the employment of Dr. Quinggu Kui and Keating Chang, provided that A, these documents be deposited in both official languages with the Law Clerk and Parliamentary Council no later than 2 weeks following the House's concurrence in this recommendation. B, the Law Clerk and Parliamentary Council remove information which could reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation. And C, these documents be laid upon the table by the Speaker at the earliest opportunity once vetted and referred to your committee.
Thank you, Mr. Jennis.
Can I now speak to that? Maybe we want to get text language clarified, and then I'd like to make some comments about it as well.
I want to see, that's a lot
to
write down, and she may wish to confirm some of that wording.
If you can please repeat, please, or if you can send me a copy by email, that would be great as well.
Yes, I would be happy to do both. Should I, Mr. Chair? I'm in your hands.
If you can send it by email, then I'll let you carry on with debate.
Sure. And Mr. Speaker, colleagues, the purpose of my motion, I greatly respect and appreciate. Pardon me, Mr. Chair. I greatly respect and appreciate the effort put forward by Ms. Zahn. I do note that adopting a motion without a timeline or a consequence would seem to me to be not as strong as the action the committee has already taken. So I would suggest we add a clear timeline underlining our expectation to receive the documents. And if we don't receive the documents, we could have Mr. Stewart back here again. But that would seem to me at a certain point, to be banging our heads against the wall. And so I think we need to report this matter to the House. I got the implication from Mr. Roy's comments, although I completely disagree with his interpretation of the law here. I got the impression that he might be more likely to advise compliance if the House ordered the production of the documents. And so my amendment says that if the documents are not provided, this matter will be referred to the House. And then it is up to the House to request the production of those documents if they wish. And that might carry more weight, although I think many of the same issues apply, but that might carry more weight in the eyes of Mr. Roy and Mr. Stewart. So I think rather than just repeating ourselves, we should position ourselves to respond if a repeat of the motion is not complied with. Hence, I think the importance of the amendment.
Thank you, Mr. Jenness. Mr. Oliphant.
Thank you. And I had intended to speak to the motion, but I am happy to speak to the amendment. I support the idea that the motion isn't complete, but I think that the amendment actually is is presupposing something that we don't necessarily need to presuppose at this time. And I don't think that's about consequences. I think that's about tying the committee's hands too early, and we want to take time to do this well. So I won't be supporting the amendment as it is, even though I'm not totally against it. What I think I would do if we were to defeat that amendment is amend the motion differently to very explicitly ask for the law clerk to review the documents, which I think was in Mr. Harris's mind, to review the documents with an eye as to the appropriateness or validity of the redactions, and then advise the committee on that. And I think that if the law clerk had two sets of documents, redacted and unredacted, he's our lawyer. He's our legal advisor. He looks at them, he reviews them, and then does a report to us. We bring him back. And at that point, if he has advised us that he thinks that the documents are inappropriately or overly redacted, then we could make a motion similar to what Mr. Jenness would do, because I think that's a motion I've heard before. I think it could make sense, but it presupposes an outcome from an event that hasn't taken place yet. So what I would say, and I don't know whether 7 days is appropriate. I think I don't see anything wrong with that. So sort of I can't really give a notice of motion amendment, but signaling to my colleagues on the committee that I think we should defeat that motion as a premature motion and or a premature amendment, which really changes the nature of this quite a bit, and does something that I think the committee might want to do or might not want to do. But let's take our time and do this one step at a time. I think that would be in the spirit of where we were on the first motion. We brought back. We now have the fuller set of documents. We brought back the agency. I'm a little nervous they haven't had full time to explain things, because I think very important questions could be asked by other members, but that's okay. We are where we are, and still I would say let's take our time. I would advise, again, I'm repeating myself the third time, as you excuse, but I think that it would be important to defeat that, but very clearly ask the law clerk to do a task for us, advise us, then we can entertain the kind of motion that Mr. Jenness has in mind.
Thank you, Mr. Oliphant. Mr. Bergeron.
Monsieur le Président.
Chair, I have the unpleasant feeling that perhaps my speaking time has been seized away from me, but nevertheless, I will express myself on this motion proposed, or this amendment proposed by Mr. Genus. First of all, what I would have liked to have said if I'd been able to intervene for the second round of questioning, Chair, would have been the following. Namely, for their own specific reasons, people on the PHAC decided not to reveal in public information that was requested of them. The committee gave them the opportunity to disclose this information to the House Commons Law Clerk and Parliamentary Council so that they would be able to give their opinion to us about the way in which this information should be treated. As I said earlier, Chair, parliamentarians are not irresponsible people, and we're not going to render public information which is of a personal nature, nor information that could have an impact on national security, nor information that's covered by criminal investigation. Consequently, I believe that what was already planned was that, and this is my reading of the motion that's just been read out to us by the clerk, namely we asked the Public Health Agency of Canada to provide us with the unredacted documents through the Law Clerk and Parliamentary Council, who would then be able to advise us how to proceed further. But the Public Health Agency, surprisingly, did not take up this outstretched hand by the Parliament to share information that perhaps could not be rendered public, and treating the Parliamentary Committee like any other litigant that would come and ask for information from the Public Health Agency of Canada. And my fear, which I was trying to say earlier, was that we are leading to an escalation of a situation where the Public Health Agency will not come out as the winner. And the agency has to realise that it would be advantageous to collaborate and work with the committee and the MPs. We're reasonable people, and I don't think any of us here want to misuse or inappropriately use the information or the documents that would be sent to us that would go against the Privacy Act provisions, nor against national security or against criminal investigations. And as a result of this, we would be able to deal with this information with the necessary prudence, given the circumstances that prevail. However, I've noted that the Public Health Agency of Canada, through Christian Roy, is claiming that the committee does not have the power to obtain this document, which goes against the opinion that was presented by the Law Clerk and Parliamentary Council, of course, is referring to the constitutional provisions that apply here, and also the ruling from the Supreme Court and also from Speaker Milligan. And in spite of all this, Maître Roy is persisting in saying that the committee is not vested with this power. So what I feared is now happening. It seems that we're going towards an escalation of the situation. I don't think that's going to be beneficial for the Public Health Agency of Canada to get involved in that type of escalated circumstances. I do agree with Mr. Genus when he said that Madame Zan's motion, which I think was a very well-intentioned one, it doesn't go far enough. It doesn't go as far as the previous motion that we adopted, because there's no timeline and there are no consequences attached to this motion. But to come back to what Mr. Oliphant has said in his arguments, what Mr. Oliphant is proposing was already included in the previous motion that we adopted. Namely, if the Public Health Agency refuses to provide documents, then Mr. Stewart and his colleagues would be called before the committee, which is what is happening tonight. But I don't think we should reproduce this for the nth time, because it seems that we're in impasse and there's a deliberate a deliberate intention on the part of the Public Health Agency of Canada, advised by Mr. Christian Roy, to not provide the document that's been requested to the committee, whether it's through the law clerk or otherwise. Now, it's a real pity in these circumstances, because I would really have liked us to have been able to come up with an acceptable compromise with those who head up the Public Health Agency of Canada and with Mr. Roy, because as I've already said, for the umpteenth time, I'd like to say again that we are reasonable people, and there's no reason why the MPs would like to overshoot their powers and render public information that would then go against the provisions of the Privacy Act, or would contravene national security considerations or police investigations. However, it is not up to the Public Health Agency of Canada nor Maître Roy to determine whether or not they should produce these documents. This is a legal obligation. It exists, and given their deliberate and repeated refusal to provide this, I don't have any other choice rather apart from saying that I'm going to vote in favour of Mr. Genus's motion. Thank you, Mr. Bergeron.
Mr. Harris.
Thank you, Chair. I'm happy to join in this debate on the motion of Ms. Zahn and the amendment of Mr. Genuis. First of all, I suppose a little disappointed we didn't get to ask some more questions about the nature of the documents and what other documents there were that had already been made public, or whether these were made public already, so we'd know a little bit more about the nature of what else is there. But I guess we're already into this particular debate now. But I will say this, that I believe that Mr. Roy either misrepresents or misapprehends, and I say this with great respect, the ruling of Speaker Milliken. And I say this from some experience, because I was on the Afghanistan committee that demanded these documents or requested these documents under the parliamentary procedure, which was turned down, and the matter went to the House, and there was a debate, and that was a lengthy debate in the House, which I participated in, and the ruling was very clear that the House of Commons and the committees were entitled to these documents. Whatever documents were available, the committees were entitled to them. And if the committees couldn't get them, the House was able to make an order. The only distinction was one that we've provided for here, what Speaker Milliken said, that I will delay making an order until the parties in the House had an opportunity to decide determine what measures they may wish to take to protect the public interest with respect to the release of these documents, because these were matters of international relations that involved potential breaches of the Geneva Convention and very serious matters of breaches of international law. And so what happened was the committee was formed. I was on part of the committee to determine what the nature of the mechanisms would be. And the committee in the majority, and I wasn't part of the majority, decided a particular route to go and presented that back in a report to the Speaker. As this is what the Parliament in majority, it was a minority government, but the majority of parliamentarians supported a particular method of dealing with the documents. And then the Speaker said that he would then implement that. Now, we have, in our wisdom or lack thereof, depending on what ultimate ruling might be made, we've provided for that. In our consideration of the request for the documents, we knew we were entitled to the documents. We had advice from Mr. Dufresne as to how that, what the rules were, and we went through the process, got proper legal advice from the Parliamentary Council, which was consistent with the ruling of Speaker Milliken, a very seminal ruling. In fact, probably the leading case on that subject in the parliamentary Westminster parliamentary democracies. And we provided that for that in paragraph B of our ruling, saying that the law clerk shall discuss with the committee at an in-camera meeting information contained in the documents, and we look at which ones in his opinion might reasonably be expected to compromise national security or real details of an ongoing investigation, etc., and determine so that the committee then may determine how to maintain the public interest in keeping the matters private. Well, that is the step that happened after the Speaker said the committee was entitled to these documents, or the Parliament was entitled to these documents. We have taken that step. And if Mr. Waugh decided that he wanted to engage in a discussion with the committee as to what measures we had proposed and whether he was satisfied with them, that would have been a different matter. But what we have from Mr. Waugh is essentially saying, no, you don't have those powers. You're not entitled to these documents. That's not what the ruling said. So we really don't have much choice here at this point, but to find out whether or not the ruling of Mr. Speaker Milliken is a ruling that is going to continue to be upheld or not. I mean, this ruling, in fact, laid the groundwork for allowing committees to do their work in Parliament and follow the convention that and this is not. It wasn't the convention invented by the House of Parliament of Canada, but it's been used in other legislatures elsewhere and parliaments elsewhere in the world to ensure that the Parliament has its rights to access to these documents, but that they would undertake to find ways of ensuring that the public interest was protected. So that's what's before us now, and I think Ms. Zan's motion was quite in order. The amendment, and I would say, though, I haven't seen the written amendment, so before we would even vote on it or choose the wording or would decide whether to amend it, I think we should all have a copy of it so we can look at it ourselves. But I think it is incumbent upon us not to let this matter drop and say, thank you very much, Mr. Waugh, we'll accept your argument, because we don't agree with your argument. And unless Mr. Dufresne tells us that we're going down the wrong road here, then I think we must proceed to obtain the opinion of the House, or the Speaker of the House for starters, and the House itself, if to be able to determine what documents that we are going to receive, because it is a fundamental constitutional principle, has been clearly stated by Mr. Dufresne. And if the government or the civil servants in this case, I don't know who's making the decision, whether they're making the decision themselves or on instruction from someone else, decides that this is going to be an impasse, well then, we have no other choice and no other course of action open to us except to proceed. There may be some further discussions about what the best way of protecting the public interest is, but that's a discussion that's taken on the basis that we are entitled as members of Parliament under the parliamentary privilege rules to have access to these documents. So if we could have a copy of the documents and have a further opportunity to discuss whether this is the exact direct, as Mr. Oliphant says, there may be another route to go other than the specifics of this motion, but I think the general thrust of the amendment should be followed, and we should move further than we've gone so far.
Thank you very much, Mr. Harris. Before I go to Ms. Zan, Madam Clerk, you've indicated that there may be some issue or that you wanted to mention in relation to the amendment motion to amend.
Yes, thank you, Chair. I just want to say that I got the motion. Thank you very much. It's only in English, so I cannot share with the members right away. But I did send a copy to the interpreters, so I'm wondering maybe Mr. Jennis can repeat, and we can have that in both official languages through interpretation. I do have a question. So the amendment would be to recommend that the House order for the documents, essentially. I just have a question for Mr. Jennis. There is another option that would be, raising a question of privilege and then reporting that to the House. And a question of privilege follows a very specific procedure in committee. And I do have a draft report that is ready if members wish to have a copy of that in both official languages. I try to be ready for everything. So it's really up to the members if they want to go through recommending the House adopts an order for the production of documents, or raising a question of privilege and reporting to the House that way.
Thank you very much,
point of
Madam
order.
Clerk. Mr. Dennis, on a point of order.
Yes, if I can just clarify quickly my motion by responding to Madam Clerk. First of all, I just sent you an email with the French version, so hopefully that allows it to be distributed. Secondly, I was very intentional about this amendment not raising the question of the privileges of the committee. I understand that questions of privilege have different implications for the House, and that is a further option that the committee has before us. And I would propose, if it's agreeable, given that you've done the work of preparing that draft report, that you do distribute that to members so we can have it for our consideration. But that is not the amendment I'm proposing. The amendment I'm proposing is, and you noted this in your comments, the amendment I'm proposing would say that if the documents are not provided within 7 days, that a report be sent to the House which, if concurred in, would amount to a House order for the production of the documents. It would still, at that point, not be a privilege issue. It would be a House order. So, Madam Clerk, correct me if I'm wrong, but I have intentionally stopped short of taking this to the furthest possible extreme.
And the clerk is nodding in agreement, it appears. So I'll go to Ms. Zann now.
Thank you, Mr. Chair. Regarding the original motion, my original motion, I just wanted to say that I had said at the end of it something that Mr. Oliphant repeated, and that was requesting that the parliamentary law clerk review them and ascertain the fairness of them. So that was actually in my motion. So that we ask PHAC to forward unredacted docs to the parliamentary law clerk and request him to review them to ascertain the fairness of them. That was the actual motion. And my question for you, Mr. Chair, is that, are we going to vote on that motion? Or I'm certainly willing to listen to more questions and ask more questions if people would prefer me to take my motion off the floor. I can do that too.
Well, the motion, we're presently debating a motion to amend your motion, Ms. Zann, and that motion to amend is on the floor. Prior to that, your motion's on the floor. As I understand it, that motion now belongs to the committee, and so an individual who's moved motion can't just retract the motion. The committee now has possession of the motion once it's been moved.
Thank you. Just if they could make sure that last part is on there. Thank you.
I think you can, perhaps you could, I think the clerk may have that wording, but perhaps.
She didn't repeat it when she repeated it. It wasn't part of it.
Maybe perhaps you could text or email her to make sure that the wording is right, if you don't mind.
I don't know if I have her email.
Okay, well let me ask the clerk to check that then, please. Madam Clerk, do you have the wording that as Ms. Zann has stated it?
So what I said previously was that the unredacted documents from the Public Health Agency of Canada be provided to the Law Clerk and Parliamentary Council. Now I do have another part, to review and ascertain, and then I'm missing the words.
The fairness of them.
So that motion is before us. The motion to amend that motion is also before us, and we're debating the latter at the moment.
Point of order.
Just Mr. Williamson, I'm talking about a point of order at the moment, and so either of those could be withdrawn, but only with the consent of the committee. Mr. Williamson, a point of order.
Yes, I thought we were working off the motion that was put forward by MP Zann, that the clerk read, and then MP Genuis has made an amendment to modify, and that is the debate. I'm not. I guess my question is, it seems like MP Zann has now come in and added other words. I don't know how that impacts Garnett's amendment, but I just want to make sure we're not amending the motion while we've been discussing the amendment to it.
So as I see it, Ms. Zan has indicated that the motion she made was not received. The clerk didn't get all the wording of it.
Well,
yes,
point of order on that. I mean, the motion as she put it forward was read by the clerk. That was her time to correct it, and I'm not. And it seems odd that we're having that amended now. I hear what you're saying, but I think if she's permitted to do that, then MP Genuis should be allowed to tweak his. I'm not sure having the law clerk judge fairness is in his purview. That is a question, I think, for legislatures. He's here to provide us legal counsel. So I worry that term fairness is modifying her motion in a way that Garnett did not respond to, and he should be given the ability to do so if he thinks necessary. Thank you.
Thank you, Mr. Williamson. I wonder, Madam Clerk, could you read the motion as Ms. Zan is indicating it was he first made it, and then could you read the motion to amend, please?
Yes, so absolutely. So what I got from the first motion that was moved from Ms. Zan was simply that the unredacted documents from the Public Health Agency of Canada be provided to the law clerk and parliamentary council. But, it's very possible that I missed the last part, but that was the version that I had. And then I have the amendment from Mr. Genuis that I sent to you all by email maybe 2 minutes ago. I can maybe read that as well.
Yes, please.
OK. Si vous me permettez, je vais le lire en français parce que M. Genuis le propose en anglais.
So I read it out in French, and it reads as follows: within 7 days, and should the documents not be provided, that the committee report the following to the House. Your committee recommends that an order of the House do issue for all information and documents in the care, custody or control of the Public Health Agency of Canada and subsidiary organizations respecting the transfer of Ebola and Henipah viruses to the Wuhan Institute of Virology in March 2019 and the subsequent revocation of security clearances for and termination of the employment of Dr. Cheng Gu and Keding Cheng, provided that these documents be deposited in both official languages with the law clerk and parliamentary council no later than 2 weeks following the House's concurrence in this recommendation. B, the law clerk and parliamentary council remove information which could reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation, and C, these documents be laid upon the table by the Speaker at the next earliest opportunity once vetted and referred to your committee. Thank you very much, Madam Clerk.
See it, Ms. Zan made her original motion, proposed her original motion. That the wording she had would be on the record of the committee. She's indicated that she's assuring us that she's now that wording that she's now giving us the correct wording to ensure that it's correct. But however, what's before us is the motion to amend. If that is once that motion to amend is dealt with, we're back on the original motion, which itself can be amended, of course, again, or it could be further amended. So if some of this wording were not acceptable, that's one way of dealing with the matter. Now, I still have Ms. Zan's hand up. I have Mr. Oliphant and Mr. Harris. I don't know if any of those are on the point of order. Mr. Oliphant on the point of order.
No, it's on the amendment.
Okay.
So, Chair, just a brief point of order for me. I understand.
Genuis.
I understand what you've ruled with respect to Ms. Zan's point. I just wonder if the additional text that had been missed could be reread out so that we all can make note of it, and then we can proceed.
Madam Clerk.
Yes, so the additional text would be to review and ascertain the fairness of them, speaking of the redactions that were made.
To review and ascertain. Thank you. Thank you very much. All right. Now, Ms. Zan, your hand is still up. We wish to speak on debate.
Yes, I just wanted to reassure the the committee. If you played back the tape, I believe you will hear me say these words in the very beginning when I first suggested this motion. Thank you.
Thank you. I have Mr. Oliphant and then Mr. Harris.
Okay, I'm getting somewhere here. I think it was helpful for Mr. Genis to explain his amendment a bit more fully, and he may be surprised, but I don't hate it. I actually think there's something helpful in it. I still think it's premature, but because we have Mr. Stewart here today, I'd like to just engage a little bit in this to see if we have heard from his lawyer at Justice, but we haven't actually been able to engage with the Public Health Agency to see if we can come to some agreement from the Health Agency about what it is that we could promise or do or undertake to get the information that we want. I am going to be very clear, and this is going to be one of those awful Rob Oliphant moments where, and I have many lawyers in the room, lawyers are not always right. And justice lawyers are particularly, in my mind, not always right, having beaten them at the Supreme Court of Canada on the genetic discrimination law, which they fought all the way through. And I have learned to now question our Department of Justice lawyers. And that has happened more than once. We had Department of Justice lawyers which advised the CSIS with respect to retention of data and information. And when I chaired the Public Safety Committee, I was horrified that for 10 years, Department of Justice had advised CSIS with respect to retaining information. I say that to predicate this and to caution Public Health Agency of Canada to get a second opinion. It's full of doctors. And I think you need a second opinion because I think that the Justice Department is not giving you the best advice. And I know that is very difficult, and I am on the government side, but I am concerned, and it follows up on what Mr. Bergeron said, is we value the public service of the Public Health Agency of Canada. We want to work with you in a way that finds a way that we can get the information we want and assure you of the integrity that we will maintain about that information and do it in a way. And maybe the way Ms. Zan had suggested with respect to having our lawyer review it first, there may be another option that you can come up with that says we get out of this without it being as big a deal as it's becoming. If it gets there, I will support Mr. Genis on taking it to the House and affirming that. I will absolutely do that. But I think there's got to be some give and take in this discussion. I think you're here. Yes, you have counsel. Your counsel has drawn a line in the sand that I disagree with, and I don't think it stands up to our understanding of what our constitutional, not only our right is, but our responsibility as parliamentarians. And we have that responsibility because ultimately there's a supremacy of Parliament over the other branches of government. Ultimately, that's it. And I'm just wondering how we can get this out of this kind of a motion and, you know, this and that, to get a way of saying, what would it take for, and if it's zero, I get it. If there's nothing we can do to assuage your concerns about the privacy and your integrity as public service under the laws that you fall under, I get it. And then we'll go with Mr. Genis's route and go to the House and see where that leads us. I'm just trying to find a more constructive way to get us into this, to get us out of it, so we have the information that we need to fulfill our responsibility. And you have the assurance that you aren't breaking laws or that your integrity is intact. We don't want to do that. You're an important agency under a huge stress at this time. Let's be very clear as parliamentarians. We know that, and I've worked with the Public Health Agency in the past. You don't know that, but I've got grants from them, so I'm but that was in my previous life at the Asthma Society of Canada. You're busy all the time. You now have a pandemic and you are hugely busy. So we don't want to cause more problems. We want to find a solution and do our work. And I'm just, sometimes the parliamentary procedure and following these rules just takes us down these motions, whereas I want to stop and say, let's work this out. And I will repeat, if there's nothing that we can do to assuage your worry, then we'll have to go down the route where we report to the House. And I will support Mr. Genes's amendment to that motion. And I don't know how we do this in a procedural way, Mr. Chair, to find some way for a non-committee member to talk during a debate on a motion that got put in when we were still on questioning the witnesses. That's the awkward part. But I think with unanimous consent, we could have Mr. Stewart respond, even though he's not a member of the committee, but that's up to you. There, that's
okay.
Rob.
Well, thank you very much, Mr. Oliphant. I have Mr. Harris next, and then I can ask if members wish to hear Mr. Stewart's response, unless Mr. Harris wishes me to do that first. Mr. Harris?
No, let me say, first of all, I appreciate Mr. Oliphant's comments and understanding that there are various ways to go. What we're looking for, obviously, is to find out the truth of the matter so that we can determine whether we can do our duty and our obligation, as Mr. Oliphant pointed out, to make a determination whether there's a matter that is of sufficient public interest for this committee to go further. But I did want to point out, having seen the amendment, because we're talking about the amendment now, and before we get on to what Mr. Stewart may think of this turn of events, he may think nothing of it and just rely on his legal advice he's been given. But the motion that Mr. Genuis, the amendment that Mr. Genuis has made, and I agree with Ms. Zann, by the way, as to what her original motion was, but the amendment suggests a somewhat different procedure than our original committee decided on in terms of how to handle this matter. As far as it gets to giving the documents to the law clerk goes, I think it's the same. But then there's a significant difference between what Mr. Genuis's amendment proposes and what's in the paragraph B, I call it, of our motion. In our original motion, it says that the law clerk will get the unredacted documents, but then the law clerk and parliamentary counsel should discuss with the committee in an in-camera meeting the information contained therein, which in his opinion might reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation, so that the committee may determine which information is placed before a committee. In other words, acting on the advice of the parliamentary law clerk with the knowledge of what is in the documents, what kind of investigation it is, et cetera, but what's to be made public and what's not, that decision is in the hands of the committee. In the case of Mr. Genuis's amendment, the documents are deposited with the law clerk no later than 2 weeks, et cetera. Then the law clerk and parliamentary counsel shall remove information which could reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of et cetera, and then to lay these documents on the table of the House by the Speaker at the next opportunity, and then once vetted, after it's vetted, I guess, and referred to your committee, so that it puts the law clerk in the position of being a judge, as what is in his opinion, and he decides and he takes the documents away. That takes away the decision of the committee as to what is relevant or what is being done, and puts it in the hands of the clerk. Now, that may be more acceptable to the committee, and that's up to the committee to accept this. I prefer, in fact, the original wording of our committee as a way to go, that we do have someone who receives the documents initially, they're kept in secret and private, and then we receive advice as to how to handle them, and we govern ourselves accordingly. That's fine with me. That's the proper way to go. The other procedure is a little bit more bureaucratic in one sense, or turns the law clerk into a judge, which he may not wish to be, in fact. But that's a different matter. I think that's worth knowing, and I think it's a reason that I would suggest to Mr. Genuis, or ask Mr. Genuis to explain why he chose that method rather than ask the House of Commons to determine that our procedure, in fact, be followed. That's a point that I wanted to make, but I do want to go back to what Mr. Oliphant was saying. I'm not sure we're in a position to negotiate in public with Mr. Stewart as to what would be acceptable to him. It doesn't seem to me that we have all the tools at our disposal to be able to do that tonight at this meeting. But I think it would be worth hearing whether or not there has been some decision made in the bowels of the public health agency or the government that this is a matter that is black and white as far as they're concerned, and we are going to go to the wall on this, or whether there is a potential for some further discussion with the Public Health Agency of Canada as to how to get to the bottom of this, because in essence we don't know what's going on. We're not. I don't. You know. We don't. We shouldn't be going on a fishing expedition, but we should have some better knowledge of what it is that are in these other documents, what is going on that was being kept from us, and so that we can determine whether it's not a matter that we have any interest in, or in fact, on the other hand, that it's a serious matter that deserves further investigation and the obligation of the committee to look further and to go the distance and make sure that all of those documents are made available to us. In the absence of any of that, we really don't have much choice but to proceed further.
Thank you very much, Mr. Harris. Mr. Genuis is next.
Thank you, Mr. Chair. First, to respond to Mr. Oliphant's comments, I think it's important to underline that Mr. Stewart and the Public Health Agency retain many off-ramps after this motion with the amendment passes, if it is to pass. This motion calls for the production of documents within 7 days. Of course, the easiest off-ramp would be for the Public Health Agency to then provide the documents, and there's no report to the House. If they wish to pursue a compromise proposal, they could certainly bring that to members and therefore through members to the House, and the House could decide not to proceed with a concurrence motion, because the request by the House for documents only takes effect if it is concurred in by the House, which is far from an automatic process. So there are other steps in the next 7 days and prior to a prospective concurrence, which 7 days from now is a break week. So any concurrence couldn't possibly happen until the following week. So, I would suggest that this motion puts in place a series of initial steps that can be taken, but it doesn't oblige the taking of those steps, and it leaves the door open for compromise. So my suggestion would be, very much, I think, in the spirit of Mr. Oliphant's comments, let's adopt the amendment in the motion, and let's encourage the PHAC to take those off ramps, but note that we have a path laid out if they choose not to. Mr. Harris, rather than give you my motivations for wording it the way I did, let me just say I'm persuaded by your arguments and would support an amendment along the lines that you proposed.
Thank you, Mr. Genuis. Ms. Zann.
Thank you, and thank you for that explanation. And I just wanted to say that I agree with Mr. Harris. I definitely thought that he had a very thoughtful response, and I would agree with that.
Thank you, Ms. Zann. Mr. Williamson.
Thank you, Mr. Chair. In fact, I just emailed Jack suggesting that he propose a sub-amendment. So, Jack, I'll yield my time to you because I think you've convinced your colleagues here that your concern is valid, and we should make that change to the amendment to the motion that's on the floor.
Thank you very much, Mr. Williamson. Mr. Harris.
Well, I would wish to propose that sub-amendment that would have the effect, and if I can do this with a little assistance from the clerk, and that the B, where after the wording that says these documents deposited in both official languages with the law clerk and parliamentary council no later than 2 weeks following the House's concurrence in this recommendation, paragraph B, that is in Mr. Genuis's sub-amendment, be replaced with the paragraph B that is in our original motion. And that reads as follows. B, that the law clerk and parliamentary council discuss with, and I think we probably should have to name the committee, I guess the Canada-China Committee, in an in-camera meeting, information contained therein, comma, which in his opinion might reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation, comma, other than the existence of an investigation, so that the committee may determine which information is to be placed before a committee in public.
And I think you mean the Special Committee on Canada-China Relations, of course.
The Special Committee on Canada-China Relations. I asked the clerk to help us with that, with proper wording.
Madam Clerk, are you able to assist us in this regard, or assist Mr. Harris?
Yes, so I do have it here. We're essentially taking the B from the motion that was adopted on March 31st, 2021, and just replacing the B from the amendment from Mr. Genis as a sub-amendment. And when we are doing motions in this committee, we don't need to put the name of the committee because it's understood that we are talking about this committee.
Only, Chair, I would suggest that perhaps if this is something that's going to the House, it might have to identify the committee some way or other.
Well, if it's going to the House, it would be by way of a report from the committee, would it not?
Well, that's fine. Whatever is the proper precedent, I rely on the clerk's advice on that.
Madam Clerk?
Yes, absolutely. You would have the headline that says Special Committee on Canada-China Relations, and then the text of the motion.
Thank you. Okay. But there's nothing, it currently doesn't say report to the House, does it?
Yes, it does.
Thank you. Okay. Mr. Harris, your hand is still up?
Only by accident, Chair.
Well, we all do that sometimes. Mr. Oliphant, I presume that's not by accident.
No, maybe by regret. It's I'm in favor of this. I would just say I would prefer that kind of happen before it goes to the House. That I think it comes back to committee before it goes to the House. However, I can live with this. So it's to me the timing should go from the law clerk to us to the House that way, but I can live with this, and so would support the sub-amendment, which would mean I would be supporting of the amendment, which would mean I would be supporting of the motion eventually.
Thank you very much, Mr. Oliphant. Is there anyone wish to further debate the matter? Seeing Mr. Harris.
I would just add, and given Mr. Oliphant's experience in dealing with either the Public Health Agency or within government, the timelines that are being proposed here and the opportunity for the potential of a compromise is what are your views on that? Does this give? Is this indeed a setup that might lead to some opportunity for reason to prevail, shall we say?
And Mr. Oliphant has used the raised hand function, which makes me think he wishes to reply.
I think, and it's in the context of the pandemic, giving the health agency a little bit longer also gives them a little bit longer opportunity than the 7 days to negotiate or to rethink and to come back with something. I think there's, if we could, but we can't do a sub amendment. So I would only try to get unanimous consent to move that to 14 days instead of 7 days. I just want to respect the fact that these people are already working 7 days a week, 15 hours a day kind of thing. So I'm just going to try for 14 days. If we could get unanimous consent, we could do it that way, but I know I can't make a sub amendment.
Well, thank you, Mr. Oliphant. Is there an objection to Mr. Oliphant's request for unanimous consent to
no, there's no
change
consent.
Thank you. I have Mr. Harris next.
Just didn't lower my hand. That's all.
Thank you. I have Mr. Fragiskatos.
Thank you, Chair. I go back to what we just heard from our colleague, Mr. Oliphant. Public Health Agency of Canada is working day and night. I think every party will or ought to admit as such. And if it's not going to be 14 days, would through unanimous consent the committee consider 10 days as a compromise? I mean, we've gone this far. I think there's a great deal to be said about the maneuvering on our side to meet in the middle somehow. Instead of 7, can we go to 10?
Mr. Chair, just a point of order.
Mr. Janice, on a point of order.
With great respect, I mean, we're on a sub-amendment of Mr. Harris. And so my suggestion would be we complete consideration of that sub-amendment. That might give members a couple minutes to chew on Mr. Fragiskatos' suggestion. And frankly, the appropriate time to consider that suggestion would be once we're back on the main amendment anyways. So why don't we just take the vote on the sub-amendment and then return to this issue?
I think that, well, I have people still wishing to debate, it looks like. Mr. Fragiskatos, you were finished? I think your hand is now down. Mr. Harris.
Yes, and I guess since we're perhaps being a little bit picky here, and I did ask, I invited the question, I think it would be very, very useful and instructive to those who are paying attention that any decision of this committee of this kind be unanimous. And if that's possible, I think it would be of more force.
Thank you, Mr. Harris. Mr. Dubois.
Bon, merci, Monsieur le Président.
Thank you, Chair. Well, from a procedural point of view, I'm trying to follow all of this. First of all, we had a motion from Ms. Zan. Then we had the amendment that was proposed by Mr. Janice, and now we've come back with another amendment from Mr. Harris. And when Mr. Oliphant made his proposal, then right away we put that to the vote. So, Chairman, could you please try and coordinate these amendments and sub-amendments, and so that we can then vote in a reasonable way on a motion or on what's being presented? Because there's several changes. And then there's a proposal from Mr. Fragiskatos that has come into all of this too. As you know, we need to go through this stage by stage, have an amendment, then a vote, then a sub-amendment, and then come back to the final motion for that to be adopted. So I think it'd be good to take a stage-by-stage procedure with full respect. Thank you, Mr. Dubois. I have the impression that I have to deal with the sub-amendment first, and then the amendment as amended by the sub-amendment, and then after that, the motion as amended perhaps by the two or not at all amended if the amendment, the sub-amendment are not adopted. Am I right, Ms. Clerk? Thank you very much, Clerk. So, Mr. Dubois, have you finished with your intervention? Well, then we'll go on to Mr. Bergeron. Thank you, Chair. I think that we've made a great deal of progress together as MPs. I completely agree with what Mr. Harris has said. namely that it would be appropriate to be unanimous. I think that Mr. Fragiskatos has come up with an honourable form of compromise. So I believe that we should unanimously, in a consensual way, accept this proposed compromise, and then all of this could be also adopted unanimously. I don't think we should be divided at all on any of this. I think there is merit in being unanimous, as Mr. Harris has mentioned. In particular, in the light of the frank debates with the government party, I think that we owe it ourselves to actually accept this proposed compromise. Thank you, Mr. Bergeron. Now, I think it was Mr. Dennis who'd mentioned that the moment to debate Mr. Fragiskatos' proposal is when we go back to Chair, if I can intervene, please. Mr. Oliphant proposed 14 days, and by unanimous consent that was refused. Then Mr. Fragiskatos asked for 10 days for unanimous consent, and there has been no decision on that unanimous consent for 10 days. So I just wanted to flag up that if this request for unanimous consent is requested, and I think we should do that, then I would give my consent to go for 10 days. Thank you. I think that is going to be requested, but that will be once we've already dealt with the sub-amendment, then go back to the amendment. Now, I don't see any other hands up at the moment.
The sub-amendment. Is anyone opposed to the sub-amendment? Seeing no one opposed to the sub-amendment is carried. So we are back to the amendment. Is there any debate on the amendment? Mr. Williamson.
Sorry, just for clarification, is this the amendment of 10 days, or is this Garnett's MP Genis's amendment?
So we're at Mr. Genis's amendment, and therefore, of course, if someone wishes to change to 10 days, they can propose that during this conversation.
I will do that with a full nod to my honorable colleague, MP Fragiskatos, for 10 days. I think we should move that, and I look for unanimous consent to make that happen.
Thank you very much. Is there anyone who objects to that request for unanimous consent? Seeing none, that is adopted. And now we're on to the amendment as with the 10 days. Is there anyone opposed to the motion to amend proposed by Mr. Genis? Seeing none, that motion to amend is carried. And we are now on to the main motion.
Chair, with the main motion, but I just say there's no objection, but that is that interpreted as that it's a unanimous motion, and I would perhaps, if we get to the main motion, we should have a recorded vote so we can be very clear that it's not just nobody objected, but that there was a unanimous motion.
Thank you, Mr. Harris. Mr. Fragiskatos.
Chair, we have one of our colleagues, Rob Oliphant, has technical challenges. He's lost internet. So we've been collaborating here. I wonder if we can somehow find a way to ensure that he gets back on.
Well, I have a thought. It being 9:26 at Lake and 8:26 Eastern, and I guess 9:56 Newfoundland Labrador time. Maybe we take a 5-minute health break. Is that agreeable? I see some thumbs up. So
I have my whole file of when Rob Oliphant's not online motions to propose. So I was about to pull those out.
Just don't take over the chair.
Back, but I think it's still a good idea to take that 5-minute health break.
All right.
Mr. Oliphant, this is your opportunity to do so. So we'll see you all.
I'm back.
Oh, he's back. Forget about the health break, guys.
Health break is needed.
Everything just stopped. Everything.
Yeah. Well,
so much for health break.
We're taking order, Mr. Oliphant.
I think Garnett did it.
Mr. Oliphant.
Yeah, I did. Yes.
Suspended. Hereby suspended. You've got 5 minutes. See you shortly. So now I see Mr. Genis's hand up.
Thank you, Mr. Chair. I was just reviewing this. I wanted to propose we add one additional phrase, and I think it just kind of clarifies the procedure. So right now, what I have from Ms. Zahn's motion prior to the text we added with the amendment was that the unredacted documents from the Public Health Agency of Canada be provided to the law clerk and parliamentary council to review and ascertain the fairness of them. Madam Clerk, can you just confirm that what I've read is correct so far?
So I can confirm that we got back on Parleview to see what Ms. Zahn did say, and I can confirm that she said to review and ascertain the fairness of them.
Okay, so what I just read was correct.
Yes, that's correct.
Okay, so and I would like to just propose that we add the phrase after that, and to report to the committee on them in the manner prescribed by the motion adopted on March 31st, 2021.
Sorry, that would be where?
That would be after the text Ms. Zahn proposed, before the text that I had proposed, so in between.
All right, Madam Clerk, do you have that?
So I have, and to report to the committee on the fairness of
no, and to report to the committee on them in the manner prescribed by the motion adopted on March 31st, 2021.
So that would replace part of Ms. Zahn's wording.
No, that's not replacing anything.
It's an addition.
It's an addition. So to review and ascertain the fairness of them, and to report to the committee on them in the manner prescribed by the motion adopted on March 31st, 2021.
Thank you, Madam Clerk. Do you have that? Yes, I see thumbs up. Thank you.
Chair.
Mr. Harris on a point of order.
Yeah, can he do that? Can we do that? I mean,
we are back on the main motion as amended, and yes, as I understand it, motions to amend it are in order.
Does this all string together? We're not losing the rest of the amendment.
Well, I was planning to ask the clerk to read the whole motion in due course before we vote on the main motion, but perhaps you'd like her. Well, perhaps you'd like her to do that now, with what Mr. Genis is proposing. Is that what you'd like, Mr. Harris?
Well, I at some point, we're going on the fly here. We don't have a written version of the full motion, and it seemed to me that there's two separate things going on here. One is ascertaining fairness, which is, I'm not sure how one might do that, but which is why I guess I gathered that the amendment was made. So I'd like to really see the whole thing together at once. And I'm trying to piece together what Mr. Genuis had in his amendment, which starts off that the unredacted documents from the Public Health Agency of Canada be provided to the law clerk within 7 days. And should the documents not be provided, the committee report the following to the House. I don't know whether that still is what the amendment is. Or I thought that the amendment was the words that are in bold in what I was sent by Mr. Genuis. I don't have anything from the clerk.
Okay, well, let me ask the clerk to read to us, okay, the motion currently before us, right, and then read what Mr. Genis has proposed as an amendment to it.
Of course. So, and please correct me if I'm wrong. So the motion would read that the unredacted documents from the Public Health Agency of Canada be provided to the law clerk and parliamentary council within 10 days to review and ascertain the fairness of them, and to report to the committee on them in the matter prescribed by the motion adopted by this committee on March 31st, 2021. And then we would go on with the rest of the amendment that was provided by Mr. Genis. Would you like me to read that as well?
Yes.
Okay. And then it goes, okay, so March 31st, 2021. And should the documents not be provided, that the committee report the following to the House. Your committee recommend that an order of the House do issue for all information and documents in the care, custody, or control of the Public Health Agency of Canada and subsidiary organizations respecting the transfer of Ebola and Henipa viruses to the Wuhan Institute of Virology in March 2019, and the subsequent revocation of security clearances for and termination of the employment of Dr. Jiangyo Chiu and Keding Chen, provided that A, these documents be deposited in both official languages with the Law Clerk and Parliamentary Council no later than 2 weeks following the House's concurrence in this recommendation. And then the B that was amended, that would read, the Law Clerk and Parliamentary Council discuss with the committee in an in-camera meeting information contained therein, which, in his opinion, might reasonably be expected to compromise national security or reveal details of an ongoing criminal investigation other than the existence of an investigation, so that the committee may determine which information is placed before the committee in public, and C, these documents be laid upon the table by the Speaker at the next earliest opportunity once vetted and referred to your committee.
Mr. Harris.
What point of order?
Treasurer, point of order.
Yeah,
Mr. Chair, I don't know if maybe I misheard, but I don't know if that fully captured where my amendment was. So the second sentence is very long. So this amendment I'm proposing does not in any way touch the second sentence. It revises the first sentence to read as follows: that the unredacted documents from the Public Health Agency of Canada be provided to the Law Clerk and Parliamentary Council within 10 days to review and ascertain the fairness of them and to report to the committee on them in the manner prescribed by the motion adopted on March 31st, 2021. Madam Clerk, maybe that's what you read and I just missed it, but that's what you read. Okay, my apology.
No worries, that's what I have.
Further point of order, Chair.
Mr. Harris.
Yeah, I do note that the latter part of the original amendment of Mr. Genuis still contains talk about laying the documents on the table and then sending them to the committee. Is that the question that Mr. Oliphant raised when we were talking about this? Because the intention was really to just replace the balance of after everything after A with the B that was in the existing March 31st amendment, that after A, replace everything after A with B, which was the B paragraph in the amendment. So everything after that, and C, these documents be laid upon the table by the Speaker at the next earliest opportunity, et cetera, et cetera. That would not be necessary in my view. Is that your understanding, Mr. Genuis, that the procedure, if it goes to the House, is that the House just passes an order to have the balance of that document followed?
Mr. Chair, can I come in on that point?
Well, if I have the consent of Mr. Oliphant and Mr. Prajascatos, yes, you can. Do I have their consent? Give me a thumbs up if that's the case, please, gentlemen. You're Mr. Prajascatos? Yeah. Okay, he's all right with that. Mr. Genuis, please.
Sure, yeah. So we're talking about a couple different things, but I do think the C is still important following the B, because the C prescribes the procedure that the Speaker will follow once the documents are reviewed. So the procedure for B is that the committee considers the documents, but since it would be an order of the House, the C is still important insofar as it's that the Speaker would lay the documents on the table. So my understanding of the sub-amendment was that it was a sub-amendment to replace the original B with Mr. Harris's B, but that we would preserve the C. So that's consistent with what I thought we decided to do.
Well, that doesn't make that these documents are already in the hands of the clerk, and he's already discussing them with the committee, and the committee has them, and he's determining which information may be placed before the committee. So I don't know how they get to the House unless the clerk then takes them from the committee and gives them to the House, and the House gives them back to the committee. Well, that was Mr. Oliphant's problem, I believe, was it, sir?
Now, I have Mr. Oliphant, Mr. Prajascatos, and I believe Mr. Chong is in the room and wishes to speak. So, Mr. Oliphant.
Well, I hated to do this because we're getting into a problem where when I drew a chart of what was supposed to happen, this is not making sense to me now. And the first problem is that I think the Ms. Zan's motion presupposes two sets of documents being compared. And I think we've kind of lost that in the wording of it. It doesn't say that, but what I think her intention was that we had the redacted documents, the unredacted documents, and they were compared, and we were advised. And I would say, fairness is a word I use all the time. It's sort of, churchy and theological, and it got a just thing. I think suitability or appropriateness probably is the better word there, so that there is a process that we would engage, ask for the whole documents to be given by Public Health Agency of Canada to our lawyer. He and his shop reviews them as to the suitability, based on the criteria that we had already laid out in our very first motion, sure, comes back to us and tells us that it is suitable in his idea or mind. He doesn't do the redactions. He's got two sets of documents. Then, if that doesn't happen, if we either don't get the documents in an unredacted form or we find them unsuitable, then we have a process where we go to the House and there's an order. And they're then retrieved by the House. I'm with Jack. I don't quite know how that happens because I have several little cliffs in my drawing where I can't find the logic. And then we have something else that happens. But we also can't tell the speaker what to do. I mean, that language I was just trying to figure out. We can't presuppose we can pass a motion, take it to the House. The House can then do something. We can't tell the speaker what to do. The speaker will do what the speaker wants to do. We'll rule on something, and then we'll have something happen. So there's a string of pearls here that we put together that doesn't really work. I can let it go and just say, let the chips fall where they may, but I'm not sure we've got now a coherent set of steps. I was trying to say that because I wasn't sure when and where the law clerk got the documents and what he was supposed to do with them and to whom he was supposed to report. It felt like there was something not working to me. So that's where I'm at. I've only had a chance to draw out the problem. I haven't had a chance to come up with a solution because I think the committee is getting to be of a mind. And in very general terms, we want the ability to find out what's in those documents. We would trust our lawyer to first see them and advise us, but then we would want to see them all if he says these are inappropriate. And we would want to go to the House to be backed up and have a speaker's ruling to make sure that what we were doing was within parliamentary procedure. And we would make that demand and give them another chance to get them back to us. And then the speaker would decide what the ultimate consequences were. We wouldn't decide what the ultimate consequences were. I like the intent of, I think there's an agreement now about this, but just not sure how it's supposed to actually mechanically happen and whether it makes sense.
Thank you, Mr. Oliphant. Mr. Frederick-Skatos.
Thank you, Chair. No, on Mr. Genes's proposed wording that he wishes to add, I just don't see where the need is. I'm not sure what that. I know what he's getting at in the suggestion, but I don't think that this strengthens the motion in any way. It further confuses. In fact, I would just maybe put it back to him to leave things as they were.
Thank you, Mr. Frederick-Skatos. Mr. Chong.
Thank you, Mr. Chair. I support Garnet Genuis's amendment. I support it because we need the unredacted documents from PIAC. PIAC is telling us, has been telling the media that the termination of Dr. Chu and Dr. Cheng had nothing to do with the emergence of the coronavirus late in 2019. PIAC has been telling us and telling members of the media that the shipment of Hennepin and Ebola viruses to the Wuhan Institute of Virology had nothing to do with the emergence of the coronavirus late in 2019, ostensibly in Wuhan. But there is no doubt about a couple of things. There is no doubt that Dr. Chu and Dr. Cheng worked at the National Microbiology Lab in Winnipeg, Manitoba. There is also no doubt that in order to work there, you need secret level clearance. Clearance that they must have had in order to work there. There is no doubt that the National Microbiology Lab in Winnipeg cooperated closely with the Wuhan Institute of Virology. There's no doubt that Dr. Chu shipped Ebola and Hennepin viruses to the Wuhan Institute of Virology on March 31st of 2019, only 8 short months before the emergence of the coronavirus. There is no doubt that she trained technicians at that very Institute of Virology to establish a level 4 lab, the only level 4 lab in the People's Republic of China. And there is no doubt that the coronavirus emerged ostensibly in Wuhan a number of months later. Now, there have been references in this committee to conspiracy theories. So let me quote Ian Bremmer, who's anything but a conspiracy theorist. Today, he said this: China's unwillingness to cooperate with the World Health Organization in investigating the coronavirus's origins has made it impossible to substantiate how the disease came into existence, thereby obscuring the scientific response. Indeed, despite all the claims of conspiracy, the theory that COVID actually was inadvertently released from a Wuhan biolab remains both plausible and deeply concerning. That's from Ian Bremmer, who, I might add, the former chief of staff to the Prime Minister, has a colleague of at his Eurasia group. There are 2 theories about how the coronavirus emerged. One is that it was zoonotic. The other is that it somehow came out of this National Institute of Virology lab in Wuhan. And it's not just Ian Bremmer who is saying this. It is people like Nicholas Wade, a well-respected science writer who was the former deputy editor of Nature magazine, a reputable, peer-reviewed science magazine, who worked at Science magazine, another peer-reviewed academic publication, who worked for many decades at the New York Times, who wrote a piece just 5 days ago asking questions about where this coronavirus emerged from. The reason why I raise this is because the government of Canada's National Microbiology Lab closely cooperated with the Wuhan Institute of Virology, and the Canadian public has the right to know what the extent of that cooperation was, why these 2 scientists there were terminated, and what exactly happened with the transfer of Hennepin and Ebola viruses and any other workings and goings on between a Government of Canada institution and this virology lab in Wuhan. And that's why we need to get this information. In a parliamentary democracy, the public has the right to know. And so this committee, before it adjourns today, I hope, adopts the motion as amended and compels PIAC to produce this information that's not only required under precedent set.
Point of order, Mr. Chair. Point of order, Mr. Chair.
Point of order, Mr. Oliphant.
I'm going to raise a point of order regarding relevance, because absolutely drawing two threads that are completely unrelated together is irrelevant to this discussion. And to do it passionately and to do it with quotes is irresponsible, has nothing to do whatsoever with the motion at hand. This is not debate. This is about relevance, and relevance under our standing orders are absolutely appropriate to be raised. And by raising this in a way to draw two threads together is absolutely irresponsible and should not be condoned by this committee because it is not relevant to the discussion that is at hand. We have asked for papers about a very specific incident. We could ask virologists to come for us and ask us whether there is any relationship to the two viruses which have been discussed tonight and the coronavirus. They are separate viruses. And anybody who knows anything about viruses knows that. And this is cheap politics, and it should not be condoned in this committee because of relevance.
Thank you, Mr. Oliphant. So, as you know, yes, we have the rule of relevance. As of course, it is not strictly enforced. That members have the ability to come to the point, bring themselves to the point, and so I would ask Mr. Chong to bring it into the discussion we're having.
Mr. Chair, with respect, I don't take the floor very often in this committee relative to many other members, and I'm speaking to a point that's very relevant to the amendment at hand and the main motion at hand. And the issue is this: Dr. Chu trained people at the Wuhan Institute of Virology so that they could be registered as a level 4 lab, the only level 4 lab in China. And why is that relevant? Because the State Department of our closest ally and trading partner said earlier this year that the standards at the lab were not upheld, that they weren't operating at a level 4 criteria, that they were operating often at level 2 or 3 with very dangerous viruses. So that's why we need these documents. We need to know what the government of Canada was doing through the National Microbiology Lab in Winnipeg with respect to cooperating with the Wuhan Institute of Virology in Wuhan, China. That's why we need these documents. We are a parliamentary democracy, and under two sets of conditions, we have the right to these documents. As my colleagues have outlined, and as the law clerk has outlined, there are precedent-setting rulings that Speaker Milliken issued in 2010 on this very issue.
Order, Mr. Prajus-Katas, a point of order.
Mr. Chair, back to this point of relevance, and I've worked with the colleague opposite. I've worked with Mr. Chong over the past, since the inception of this committee, basically. Had the chance to get to know him a bit over the years. I'm really surprised at what I'm hearing here. I consider him to be someone of substance. But this moment, no, let me continue, Mr. Chair, if I could. I'm just about to wrap up.
I'm listening to a point of order, and I'll have one person speak at a time. Mr. Prajus-Katas.
Mr. Chong is proceeding to connect dots here that, he is borrowing from some of the wildest theories on Facebook and other social media to make a point here that is irrelevant to this committee. We were about to resolve an issue that we were talking about all night. We had reached a compromise motion, and all of a sudden, we've now proceeded into these, they're not even theatrics. I'm not sure. This is a very bizarre moment in this committee. I haven't seen something like this since the committee was formed, and I've been here from day one.
Mr. Prajus-Katas, thank you. I take you made your point, your view on relevance. I've indicated that the rules of relevance are not strictly enforced, but of course I've also asked Mr. Chong to ensure that he brings this within relevance to the discussion before the committee and to the subject of the committee study. So that's where we are, and Mr. Chong has the floor.
Thank you, Mr. Chair. I will wrap up quickly. What I am raising is entirely relevant and not conspiracy theory driven questions. Nicholas Wade published 5 days ago on the Bulletin of the Atomic Scientists, a reputable organization. Ian Bremmer is raising questions about the origins of this virus and the role that the Wuhan Institute of Virology played. Other people are raising questions. This is not in some dark part of the web driven by conspiracies. These are reputable people raising very real questions. And our question as Canadian parliamentarians is, what role did this National Microbiology Lab have in cooperating with this Institute of Virology in Wuhan? They trained them to a level 4 standard. They sent scientists and viruses over. We need to know what the cooperation was, why Dr. Chu and Dr. Chang were terminated. We need to know what exactly happened in the situation. And let me finish by saying this. We are a parliamentary democracy, and under 2 sets of conditions, we have the right to these documents. As my colleagues previously mentioned, Speaker Milliken's ruling of 2010 was a precedent-setting ruling, not just in the Canadian House of Commons, but in parliaments throughout the Commonwealth, that made it clear that parliamentary committees in the House have the right to seek for papers and other documents from the Government of Canada without restriction, which is exactly what we did in the motion we adopted on March 31st, some 5 weeks ago. Documents which we have not yet received in unredacted form as we requested. And statute law itself says that in respect of personal information, that our committee under Section 8(2)(c) has the right to get this information. And yet we are being stonewalled in a pandemic when the authorities of Parliament and its ability to hold the government accountable are already curtailed. So for all those reasons, I hope that by the end of this committee in half an hour, that we will adopt the amendments in the motion and that we will pass this and ensure that PIAC provides us with this information, because the Canadian public deserves to know. Thank you, Mr. Chair.
Thank you, Mr. Chong. Mr. Oliphant.
My concern on that is I think we're in agreement on the fact that we want the papers. I am confused as to what that argument was about. We want the papers. I don't think anyone on the committee has said we don't want the papers. We want to exercise our parliamentary privilege. We get that. I would say having a speaker's ruling, and it may be a question that Mr. Dufresne can answer for us. But I'm not even going to get in there, because I think there is an issue that just because the Speaker of the House says the House has authority doesn't say that the Supreme Court has said that. He has told us a couple of times the Supreme Court has said that. I've never seen a citation, so I'm not sure what that is. I'm happy at some point to have it, to see that Speaker Milliken's ruling was upheld in a court of law, because, you know, if one branch of government says they can get something, well, of course they're going to say they're going to get something, because that's their job. That being said, I don't think we're arguing about that right now. We've all agreed that this is an important set of documents. We want to do it carefully. We want to do it judiciously. We want to make sure that there could be some way that we could negotiate with PHAC to find a way they could exercise their authority and responsibility. We could exercise ours. We're not arguing. What I am disagreeing with is far-fledged ideas that even hint at some association that makes no sense. And somehow there is something embedded in these documents that's going to solve the world's question about where the coronavirus, COVID-19, came from. And I think that's bad rhetoric. I think it's misinformation. I think it's drawing associations that should not be drawn together at a committee of parliament. And I think it just seeds the oddest ideas in other people's heads. So let's get out of this. I'm happy with this motion. I think it's going to be pretty hard to figure out exactly where we go with it and how it gets operationalized. I can live with it. I can live with the motion, get it done. But there's a certain vilification that's going on here too, that I think is very problematic. But I'd just like us to get through to get this motion done, and we'll figure it out.
Thank you, Mr. Oliphant. So I have Ms. Yip, Mr. Bergeron, Ms. Zan, and Mr. Harris. Ms. Yip.
I agree with Mr. Oliphant. We need relevance, and let's just keep it simple. Let's just go back to what we were discussing. I think most of us are on board. We've already, I don't want to say wasted, but we've used up enough time. We have witnesses here that were here to answer questions, so let's move on this. Thank you.
Thank you, Ms. Yip. Monsieur Bergeron.
Monsieur le Président, bien honnête.
Chair, well, honestly, I feel as if I've missed an episode because things were going swimmingly. We were going to adopt a motion in a consensual way, and then suddenly we veered off into a completely other debate, and we've picked up the rather inflammatory rhetoric. But I thought we'd moved on to another stage where we'd all understood and agreed that we want these documents and we want to look at this in depth and really understand and grasp what happened. But I have the impression that there are certain colleagues that were afraid that the motion was going to go through too quickly. And that would mean that they wouldn't be able to continue with their diatribe based on vengeance or something like that. So I find this very strange. Well, things aren't getting better. They're getting worse, as my mother would say, from the lower St. Lawrence River. I think we should be voting on this motion that was going to reach consensus. So why are we suddenly now in this rather bizarre situation? Just a minute ago, everyone was agreeing. But now there's new tensions that have arisen, not just between members of the committee and some of our witnesses, but also just amongst ourselves. And I don't understand how we got here. I'm really astonished and I'm disappointed. Chair, could we please put this to the vote as quickly as possible because we're wasting time. And I'm afraid that this meeting is going to come to an end without being able to adopt our motion. So in a spirit of collaboration and in a spirit of cooperation which has characterized the relations between the members of this committee since the beginning of the meeting, could we please come back to the motion that we were on the verge of voting upon and upon which we'd all agreed and that we were going to vote on unanimously, I believe. Thank you very much. So I'll now turn to Ms. Zan, please.
Thank you, Chair, and merci, Monsieur Bergeron.
Thank you, Mr. Bergeron.
I would have to say that we are all in violent agreement, and we were reaching the goalpost together before this side outburst happened. We don't need it. I think the histrionics are unnecessary at this point, and we are all here working collegially together. And so, let's just get on back to the point at hand. Thank you so much.
Thank you very much, Ms. Zan. Mr. Harris.
Thank you. And to the point at hand, I think what we have now, which is put together, is first of all that we ask that the Public Health Agency of Canada provide the documents to the Parliamentary Law Clerk, which we've already asked for, and they ascertain the fairness, report to the committee using the existing procedure. And if they don't do that, we ask for an order of the House to do exactly the same thing, with one exception. At the end of doing what our motion says, that discuss it with the committee, we somehow add, and these documents be laid on the table by the Speaker at the next earliest opportunity. I think that's superfluous at this point, that everything after the word public in amended paragraph B is superfluous, because the House then orders something consistent with our motion, which is that the documents be given to the clerk. The clerk discusses them with the committee, and they decide. And then we carry on. We don't send them back to the House and then come back to the committee. That's an unnecessary step. And I thought that I had eliminated that when I moved my amendment. But apparently that didn't happen, and we still have a paragraph C in the original amendment of Mr. Genuis's, and this is part of the problem, I guess, of dealing with documents on the fly. But I want to propose an amendment that we delete all the words before a committee in public, which as it appears in paragraph B of the now amended motion, and the words end with the word public.
Well, thank you, Mr. Harris, but we have on the table Mr. Jennis's motion to amend the main motion,
okay.
right?
Sorry.
And once we deal with that, then we can deal with your, you can then propose your motion to amend.
I think that solves the logical issue that Mr. Oliphant was coming up with.
Thank you. Mr. Jennis.
Well, thank you, Mr. Chair, and I do want to say that I share Mr. Chong's concerns and passion for the importance of Parliament. But I wanted to make some just brief comments on the amendment as I had proposed it, which is that it clarifies, in the event that the documents are provided by PHAC, it clarifies that the procedure by which those documents would be reviewed would be the same procedure that was envisioned in the motion of March 31st. That's why I think my amendment is important. So my suggestion is we vote on my amendment, then we vote on Mr. Harris's amendment, then we vote on the main motion.
Well, that's in fact what I have in mind. So any other debate on Mr. Jennis's amendment? Okay. If anyone is opposed to his amendment, please show your hands, and if so, we'll have a vote. But anyone opposed to Mr. Jennis's amendment? Seeing yes, someone is opposed to it. So therefore, I'll call on the clerk to take the vote on Mr. Jennis's proposed amendment.
Okay, thank you, Mr. Chair. And just to be clear, I just distributed to all members the motion with the amendment in red. So just so everyone can be clear. So on Mr. Jennis's amendment, Monsieur Dubourg.
No.
Mr. Fragis-Catos.
No.
Mr. Oliphant.
No.
Miss Yip.
No, thank you.
Miss Zan.
No.
Mr. Chong.
Yes.
Mr. Jennis.
Yes.
Monsieur Paulus.
Oui.
Mr. Williamson.
Yes.
Monsieur Bergeron.
No.
Mr. Harris.
Yes.
Okay. So yeas pour 6, nays contre 5.
Declare the motion to amend defeated. Mr. Harris, do you wish to move your amendment?
Yes, I do. That would remove all the words after the word committee in paragraph B. Public.
I think before a committee in public, after those words, right?
Yes, after those words.
Thank you very much. Anyone wish to debate that proposed amendment? Does anyone oppose that proposed amendment? Mr. Jennis does, so I'll ask the clerk to take the vote.
Thank you very much. On Mr. Harris' amendment, Monsieur Dubourg.
Oui. D'accord.
Mr. Fragis-Catos.
Yes.
Mr. Oliphant.
Yes.
Miss Yip.
Yes.
Miss Zan.
Yes.
Mr. Chong.
Clerk, I didn't hear the amendment. It was to what?
It's to remove the words and see these documents be laid upon the table by the speaker at the next earliest.
Okay. No.
Okay. Mr. Jennis.
No.
Monsieur Paulus.
No.
Mr. Williamson.
No.
Monsieur Bergeron.
Oui.
Mr. Harris.
Yes.
So yeas pour 7, nays contre 4.
I declare the amendment carried. So now we are back to the main motion as amended. I see no one else wishing to debate it. So I'll ask the clerk to take the vote on the main motion.
Thank you. Monsieur Dubourg.
Oui. Merci.
Mr. Fragis-Catos.
Yes.
Mr. Oliphant.
Yes.
Miss Yip.
Yes.
Miss San.
Yes.
Mr. Chong.
Yes.
Mr. Jennis.
Yes.
Monsieur Paulus.
Oui.
Mr. Williamson.
Yes.
Monsieur Bergeron.
Oui.
Mr. Harris.
Yes.
And all yeas, Mr. Chair.
The motion has been unanimously adopted. Mr. Jenis.
Thank you, Mr. Chair. I would like to propose that the draft report that the clerk had referred to with respect to the privilege issue be distributed to members of the committee.
Is that the will of the committee? Is anyone opposed to that proposal? Mr. Fredriskatis?
Let me just ask, if I could, Mr. Chair, let me just ask the rationale there.
Mr. Jenis?
Sure. The distribution of the work that the clerk has done doesn't. It would be a draft report, so it would be covered by the in-camera requirements, anyways. But it's work that has been done that makes us aware of an option if we wish to make use of it at some future point. I think it's reasonable for the members of the committee to have that in front of them so that we can consider it at a future point if we wish to. But again, the distribution of that to committee members is just a matter of information and our use. It doesn't in any way predetermine a next step.
So is anyone on the committee opposed to that distribution? Seeing none, I will ask the clerk to do so. I'll take it as agreed. Thank you very much. So, colleagues, it's 9:15 Eastern. Mr. Jenis, your hand up again.
I was just going to propose that we give people the opportunity to ask questions of the witnesses in the final 15 minutes, but maybe you were going to propose that anyway.
No, if that's the wish of that's up to the committee. That's what I wanted to ask, what the wish of the committee was. And the last I had Ms. Zan, and she was 2 minutes into her 5 minutes. So Ms. Zan, if you have more questions, you may proceed, and then I'll go on to Mr. Bergeron, Mr. Harris, and Mr. Paulus if there's time.
Okay. Wow. I feel like we've gone all around the world and come back again. First of all, I have to say thank you to the witnesses for their patience. I know it's a very long night while parliamentarians are debating and you're waiting to find out what we're going to do. But I certainly hope that you will take our wishes and recommendations and requests back to the department and discuss sincerely with them and with your lawyers what to do. But we would very much like to get the unredacted report if possible. So, Mr. Stewart, first of all, could you explain to us again what exactly was being taken back to Wuhan, China, regarding the Ebola virus, etc.? Can you please expand upon that a little bit more?
Mr. Chair and member, thank you for the question. I was wondering, because there was a discussion earlier, whether you would come back to this topic, the Hanapa virus and the Ebola virus and the shipment to the Wuhan Institute. And I was wondering, Mr. Chair, if the members would benefit from asking Dr. Guillaume Poliquin about the relationship among these viruses or not. It seems to have become something in the course of the committee this evening. And in fact, Dr. Guillaume Poliquin is in fact a world expert in this exact area, and it might be helpful for the background for members if that's appropriate.
Well, if you're referring to him, Mr. Poliquin can go ahead for 1 minute and 15 seconds.
And thank you.
Thank you, Mr. Chair, and thank you, President Stewart. Yes, the materials that were shipped to the Wuhan Institute of Virology included Henipaviruses as well as Ebola viruses. These are both in the order of mononegavirales. So they are two different families within that order. It is important to note that coronavirus is part of the Coronaviridae family and are in a completely different order and kingdom. So they are not, in fact, at all related and would not have been used or relevant to SARS-CoV-2, as was previously discussed.
Ms. Zan, you have a few seconds, 20 seconds.
Thank you very much. Also, Mr. Stewart, with regards to the investigation, were you clear as to whether that was the provincial RCMP or federal RCMP that were doing the investigation?
I don't know which arm or which group within the RCMP are conducting the investigation, to be honest. All I could say is the RCMP are, in fact, conducting that investigation, Mr. Chair and member.
Thank you. Thank you. That's the end of Ms. Zan's time. Et maintenant, on turn à Mr. Bergeron pendant...
And now we'll turn for 2.5 minutes to Mr. Bergeron. Chair, I'd like to say to witnesses that you will have been able to see, apart from the last moments of our discussion on the motion, but in general, you will have seen that parliamentarians are unanimous about the fact that the committees have the right to ask for documents and information, and we are determined to move ahead with that. Now, previously, I was saying that we'd offered an opportunity to put out a helping hand, and that hand remains extended to find a solution. I would very much hope that we don't need to count on a decision being taken by the Speaker, which would put you in a very embarrassing situation. It would not be in your favour. So I'd like to repeat that we're reasonable people and we do not want to publicly unveil information, personal information, national security information, or information related to criminal investigations. Now that you've got that reassurance from parliamentarians, and the fact that we have stretched out our hand once again to find a common understanding which would avoid us having to go for a more radical solution, is there an opening on your part to find this common understanding? Or are we going to have another very unsatisfactory answer coming back from you in the next few days?
Mr. Chair, thank you for the question, Honourable Member. I want to say, first of all, I want to thank the Honourable Members. There have been many warm words said about the Public Health Agency, and I underline that for a reason. One of the members noted that our area of expertise is medicine. In fact, nursing, public health, epidemiology, statistics, and so on, which is to say that we're a public health agency. And we're not expert in these topics. Here tonight, I think listening, it's been constitutional law, Parliament, the relationship of the executive and the House Commons. These are not areas that the public health is expert in. So we're guided by experts, and we will be guided here by what the experts tell us to do. Thank you for the question.
Mr. Stewart. Mr. Harris, 2 minutes and 30 seconds.
Thank you, Chair. I would underscore what Mr. Bergeron just said in terms of the sincere attempt by our committee to formulate a way for the Public Health Agency of Canada to comply with the orders and the requests for documents, and at the same time serve to protect the necessary public interests in in not having documents made public or information made public that should not be. We are, in fact, charged with that responsibility as part of our duties as Parliament. And I would urge legal counsel, Mr. Waugh, if you're still going to be doing this, or anybody who's doing this, to have a very thorough look at the decision and the ruling of Mr. Milligan and the context in which it was made, and the references to which it took, and the fact that they're dealing with parliamentary law, which is in fact a branch of constitutional law from the UK on down. They don't even have they don't even call it constitutional law in the UK. They call it administrative law, and it's about decision making and the powers of Parliament and the powers of the various branches of Parliament, which is being adopted into our Parliament, and the ruling of Mr. Milligan being serving as a beacon to the rest of those parliamentary parliaments that act like ours with a constitutional setup and a responsible government. And I think it's incumbent upon those thorough investigations being made and consulting with people who are experts in parliamentary law. And I think you will find that this is a very good decision, and that our method of allowing the documents to be given to our committee is one which is well within that. And I would urge you to take that very seriously indeed. And hopefully we'll be able to reach a conclusion that's satisfactory to the committee and allows us to continue our investigation. And I won't ask you to comment on that.
Thank you, Mr. Harris. Nous reste 6 minutes.
So we've got 6 minutes left to be divided by Mr. Paulus and Ms. Yip. Thank you. It's the first time that I'm taking the floor in 3 hours. So first of all, Mr. Stewart. The employees of the National Microbiological Laboratory, do they all have to have security clearance, a security certificate?
No, there's a range. There's about 650 employees, and based on their duties, their classification relates to what their obligations and responsibilities are.
Est-ce que le Dr. Chu a...
So did Dr. Chu have security certificate or clearance, and at which level?
I won't be able to respond to that question about the employees for the reasons we've discussed previously. Yeah, I'll just leave it at that.
Okay.
Okay. So, Mr. Stewart, you'll see that we've got a motion from the 31st of March, which gave clear orders in the committee that has not been respected by you. And I understand that the Liberals voted against this, so we just had the opposition parties that had supported it, even though there was a majority decision. And now I'm very surprised to see that the Liberals themselves have brought forward a motion to ask specifically for the documents to be produced. So are you going to listen to this unanimous order from the Special Committee on Canada-China Relations?
Mr. Chair and Honourable Member, we actually invested a great amount of time and effort in gathering up all the documents available. And guided by experts, we redacted the materials that we were not able to provide under our understanding of law, and we provided them to you. And we're very pleased to be here this evening to speak with you about this matter. Thank you.
Mais vous répondez pas à ma question.
But you're not answering my question. We've just spent an hour and a half debating a motion that was put forward by a Liberal MP who's part of the governing party, and this motion has been adopted. You're a witness to this, and you've got your Parliamentary Counsel de Friend, you've got your lawyer, so I think there's no doubts about what's been said today. So are you now going to listen to the order from the committee and send unredacted documents as requested, yes or no?
Mr. Chair and Honourable Member, we will take the written question away and we will be guided by experts on the appropriate response.
Il me reste combien de temps, Monsieur le Président?
How much time do I have left? Just 30 seconds. So at the beginning of the meeting, you talked about security around the documents and the RCMP investigation, but you said there was no link between what you redacted in the document and the RCMP investigation. So how did you decide whether it was a question of national security if you're not an expert on these matters?
Mr. Chair, first of all, just to clarify, I made no connection of the nature being made with respect to the RCMP. I just noted there's a separate RCMP investigation underway, and we can't speak about that.
Thank you, Mr. Stewart. Merci beaucoup, Monsieur.
Thank you very much, Mr. Paulus. And now, Ms. Yip.
Thank you for staying right to the end. Mr. Stewart, it's my understanding that in cases where there is a transfer in material, certain steps can be omitted for the sake of fostering relationships and collaboration. Is that correct? And what circumstances would a material transfer agreement be required? And can you explain why it wasn't appropriate in this transfer with the lab in Wuhan?
Mr. Chair and Honourable Member, thank you for the question. So I'm going to turn to Dr. Poliquin to talk about making adjustments to the MTA, the Material Transfer Agreement. I would just note that predominantly it's an intellectual property document. So over to you, Guillaume.
Thank you, President Stewart and Mr. Chair. In fact, material transfer agreements are used as part of the transfer of materials under a set of circumstances when they're warranted, which includes the protection of intellectual property rights. There are additional considerations with an MTA as it pertains to the use of the materials, but it is important to note that under the provisions of the Human Pathogens and Toxins Act, as well as the Canadian Biosecurity Standards and the Transport of Dangerous Goods, there are additional legislated requirements in order to proceed with the transfer of these types of viruses, which in and of themselves must be met. And therefore, in this case, MTA was not deemed to be necessary since the provisions on the use of the material were covered in other documentation, and there was no intellectual property rights arising.
Cheng Chi and her students from China were removed from the lab in July 2019 over what was described as a possible policy breach and administrative matter. What has happened to the students from China? Have they also returned to China? Are they being investigated? And that's to Mr. Stewart.
Thank you, Mr. Chair. And Honourable Member, for the question, I'm not able to speak to those matters. Thank you.
Is the investigation by PHAC at the NML completed?
Yes, the investigation at the National Microbiology Lab has been completed.
What can you tell us about it?
I can tell you it's completed, and that's all.
Okay. Has there been any similar policy breaches in recent history similar to what has happened with the two scientists? And what's been done?
I don't know how to answer that question, Mr. Chair and Honourable Member. Do you mean with respect to the public?
I'm afraid
like
the time is.
Sorry.
I'm afraid
a similar incident.
Ms.
Okay.
Ship, I'm afraid the time is up. Before we conclude, I think I have to ask the members. The clerk is asking me about the redacted documents that we have received and whether it is the wish of the committee to make them public. Now, I certainly don't want to have another long discussion, and in fact, I know that the interpreters and we only have the staff not very long. So, is anyone opposed to making the redacted documents that we have received public? Mr. Oliphant?
It's just a question as to what purpose it would serve. We're engaging now in another process, and I actually think I would like to, in good faith, give the Public Health Agency an opportunity to hear our second request and do that. And I think that I would hope that the committee could understand that that would build some good faith, and we could engage in a conversation with the Public Health Agency of Canada. They will be thinking, as the President said, they'll be thinking now about our discussion, and I would sooner just say, let's do that. They're redacted documents, so I'm not worried about the security, but I would like us to give them a chance to bring us new documents.
Madam Clerk?
Just to say I have Mr. Chong in the room.
Okay, I have Mr. Chong and then Mr. Jenness.
Thank you, Mr. Chair. I support releasing the redacted documents. Thank you.
Mr. Jenness?
Yeah, I do as well. And just to respectfully respond to what Mr. Oliphant said, it's not in any way bad faith or contradictory to the process that we've already established to say that that in the midst of ongoing discussions about the unredacted form of the documents, we have already received some information, and we've had a chance to look at that information. I think we should make that information public, just on the basis of sort of government open by default, and there's nothing problematic in that material to make public. I've reviewed it, and let's start informing the public with the information we have in the midst of seeking more information.
Mr. Bergeron.
Monsieur le Président.
Chair, well, at a first glance, I think, agree with what Mr. Genius has just said. But the problem is that some of these documents were just sent to us this midday. So I'm not sure whether we're going to actually gain anything by going too fast, as seems to be the case now. I think we need to have a more in-depth discussion at a future meeting, and that would leave us with some time to look at these documents we've just received. And of course, the objective is, of course, to get all of the documents, the complete documents, and then be able to judge the relevance of each of these documents in the light of the opinions that have been offered to us by the Parliamentary Council and Law Clerk. So, consequently, Chair, even if I recognise the value of the argument that's just been advanced, I do have the impression that I'm being rather rushed, and that the discussion seems to be charging ahead, and I think it would be better to come back to that at a later juncture. Thank you.
Mr. Precious-Karas.
I do agree with Mr. Bergeron on the substance of his points, and I see that the time is now 9:35. Mr. Chair, I move to adjourn the meeting.
Thank you, Mr. Precious-Karas. Madam Clerk, please take the vote on Mr. Precious-Karas' motion.
Of course, Monsieur Dubourg.
Je vote oui.
Mr. Frégis-Karos.
Yes.
Mr. Oliphant.
Oui. Yes.
Miss Yip.
Yes.
Miss Zan.
Yes.
Mr. Chong.
No.
Mr. Jenis.
No.
Monsieur Paulus.
No.
Mr. Williamson.
No.
Monsieur Bergeron.
Oui.
Mr. Harris.
Yes.
So yeas pour 7-7, nays contre 4-4.
Thank you, colleagues, and thank you to the witnesses. The meeting adjourned.
Good night. Thank you.